Yes.
May I mention on appellate side matters? Appellate side matters, madam.
What?
Madam, I'm paying for leave to file review application on survey copy. Order
When the order was passed,
in March and application was for certified copy filed on 16th March. Next day. Not yet received.
by this bench,
Yes, ma'am. You will not.
My lord, may I be permitted to mention item number 236 of the daily combined monthly list, my lord.
we will consider it.
My lord, this is the REIT of 2011, my lord.
Whatever, we will consider it, sir. If you have waited for 11 years, suddenly it's urgency. Let us see. It will come to my chamber.
May I be permitted to mention one matter of the monthly list, 193 item number.
We take all the file and thereafter we decide whether urgency or no urgency. Give that file.
Well, actually,
it comes to us.
The BLR is going to take the possession of
Whatever you have to write.
no interim order has been passed.
Whatever you have to write.
Application for restitution.
One tribunal application, central tribunal, which was speaks from.
Give all the slips. Give all the slips. We will consider. Yes. Give all the slips.
For inclusion.
My lord, I'm only praying that my matter be listed on Wednesday. My lord, I've handed over
Sorry,
the
we
slip.
can't. You can't dictate the roster of the court.
My lord, I'll just indicate why. My lord, I have my cases of specific performance, my lord. I had applied for a plaint, my lord, and for injunction. The ad interim injunction at the ad interim stage was refused, my lord. Now, my lord, why I applied for that ad interim injunction, my lord, it's only because of the fact that I was already possessed from the property. I filed a police complaint, my lord, pursuant to which I filed my suit. My lord, I'm only praying that this matter can be taken up urgently, my lord.
We will consider it. You just write down the urgency. We'll consider.
With the leave of
Yes.
Honorable Justice Bishop, Bishop may be permitted to mention a single bench matter before Honorable Justice Tandon. This is that matter of DVC versus West Bengal Electricity Regulatory Commission that your lordship remembers. My lord, the affidavits are all complete and ready for.
Whatever. Let us see.
Lordship, in this matter, I am for WBLC.
My lord, may I permitted to mention one contempt application?
Let's call the list.
My lord, I am for petitioner. A small correction needed. My lord, correction of the order dated 26 April 2023. It was to petitioner number 5 was to a strike off, but it has become petitioner number 1 a strike off.
Give the slip. Give the order. It is the respondent number 1.
Respondent, yes, my lord.
Who
It was
who-
to petitioner. It was to petitioner number 5 was to a strike off, but it has become petitioner number 1. I am
is an
for
appellate side matter or original side matter?
appellate side matter.
So why you are mentioning? Today we are taking up the original side matter. Take it back. I was wondering that there is only only 2 parties. Yes, what is this?
One in the original side.
Yes.
Yes. Millard, order 9, rule 13 dismissed. Millard, there is a delay, Millard. Millard, restoration application filed for Millard, dismissed. Millard, strictly speaking, not for default. Millard, the honorable single judge who was taken up the matter said, Millard, the suit has become infructuous. As a suit has been decreed, the appeal has become infructuous. Hence, application has become
Section 5 is
Section 5
dismissed.
filed. So, Millard, as on Millard, I have the points. Millard, Millard, as on that date, it's not a dismiss for simplicity default. It's Millard, the honorable single judge Millard comes to a finding that the suit is become infructuous. The application is infructuous because Millard, the suit has been decreed, Millard. So, Millard, yes.
It's not that.
Yes, Millard.
Is the suit was the decreed ex parte
Correct,
on
correct.
8th April 2011.
Correct, Millard.
An application was taken out for that was setting aside the abatement was 2704 of 2011.
Correct, my lord.
The said application was also dismissed for default on 11 September
There was a
2017.
stay operating in my favor.
I do not know
Yes.
this was. Then the another application is filed for restoration of that GA
Yes,
2704.
correct. That is this.
And that application was taken out in 2023.
Correct, my lord.
So
Absolutely.
now there is a gap
Gap of
of nearly
1975 days. 1975.
whatever, nearly 6 years.
Yes, 1975 days.
6 years. So the trial court has found that there is no explanation which is given.
Yes, correct.
So if that being the correct, then why we will interfere with this order
Yes, A. Miller.
for 6 years?
Millard, A. Millard, Millard, Lordship's court have held Millard. The delay, Millard, I am carrying the judgments. Length of delay is not material.
Not Lordship's court, even a Supreme Court has said
Supreme Court has said
that
it's
the
Millard,
delay
whether-
is, the length of delay is not
there are two
material.
conditions.
It
Millard,
is a sufficiency of the cause which is an important factor. And if there is a cause which is sufficient, longer delay can be condoned. Even a shorter delay cannot be condoned.
Millard, now another exception has been made in 2021. So far as shorter delay is concerned, liberal, very liberal. Longer delay, there is one problem, Millard, since Lordship gave me, Millard. Lordship said that you should not be afraid. This is connected, Millard, with a city civil court matter.
No, it is not. It
Yes,
is the
yes.
original side of the
No,
High
no,
Court.
no. Original suit was before the small causes court, which got transferred. And Millard,
What is that suit?
Millard, kindly, Are Dana re Baba, এরকম করিস না, দাঁড়া, দাঁড়া, করি না. Kindly have a look at page 89.
Yes. So you want to get rid of this bench?
No, no, I never, Millard. Lordship said in the Tata matter, you should say me. I never said Millard previously. And Lordship was perhaps not happy with that. Lordship can hear. Not only that, Lordship knows.
Frankly speaking, because I was thinking, because order is passed in the original side of this court, the suit has been registered in the original side of this court, CS5 of 1994.
Is not.
So I never had any idea that
Lordship
the
so
suit
said, I have
would
never seen
travel
all-
from there.
And Millard, kindly take Millard. The name is Millard. The name Millard. Lordship may recognize. He is in court.
I do not recollect. Can you more elaborately indicate?
Someone called Millard Balkrishan Kedia Millard. Who was
Where is that?
Millard-
I didn't find the
Millard,
name.
He is Millard. He
It is
is the
Sandeep Kumar Jhunjhunwala and
Yes.
Uma Bose.
Yes, Sandeep Kumar Jhunjhunwala, brother Millard, he's here. Yes, Millard.
What?
He says Millard, he's the person who was looking after. He, Millard, says he was Millard basically.
No. What is why that name appeared? What is there?
He is Millard. Lordship says connected party or a known person.
Whatever. I just wanted to know the
Millard,
connection.
he is Millard. The family matters of this person's Lordship has dealt with as an advocate. He says Millard.
Released on my ground.
Grateful.
Very good way of getting away.
Not a Millard. Lordship said Millard to tell me Millard. I do not told Millard in the Tata matter Millard in the
Yes.
hearing state.
Anyhow,
Grateful.
I thought I was covered by your lordship's judgment.
I also covered Justice Tandon, my lord sitting with Justice Millard Gangopadhyay has delivered a detailed judgment on this.
Consider all the Supreme Court.
Grateful.
And I am appearing for the appellant, my lord, in this matter.
I appear for the official
This
liquidator.
is an against, my lord, an order by which the property of a company, without ascertaining whether the property belongs to the company, has been directed to be sold. But I was appointed on the basis of an expression of interest issued by the Provident Fund authorities for recovery of the certificate.
under what provision of law?
I'll tell you, Lordship, my lord.
Show us. I am also very skeptical about it.
Yes.
I do not know whether management can be given under that act.
Kindly come to page 36 once. Recovery officer has been appointed. Page 36.
I just wanted to know the source of paha.
But there was an expression of interest issue.
I'm simply asking you the source of power.
But it is an execution proceeding, recovery.
Whatever, what can be done, recovery proceeding, how the authority can deal with. There must be a power. Show us the power.
There is a Assam Act, Assam Tea Plantation Provident Fund Scheme Act.
This is what is a recovery officer
Yes,
under the Provident Fund.
yes.
Show us from the act itself that this powers can be exercised.
Just once.
Show us, sir. I just wanted on the last occasion. That is the only thing I wanted. That the authority can appoint a receiver and can direct the management of the company to be taken care of by him. Everything he will do it.
My lord, if you
Show us.
kindly take page 36 once.
I'm looking at, I have seen that you have been appointed as a receiver.
Not only that, my lord, the source of powers, first paragraph of that order. Your lord.
Correct. It says the subsection 1 of section 222 of the Income Tax Act.
Yes.
It does not talk about the Provident Fund.
No, it says.
And then this was
by virtue of
the property.
property of community estate,
Correct.
by virtue of explanation to section.
Correct. It was attached.
Attached by in the course of execution of certificate. It's a recovery proceeding.
Now I'm asking you if it is a certificate proceedings,
Yes.
whether the Public Demand and Recovery Act can and bestowed this power to appoint a receiver, to manage the property, to run the property. I just wanted to know. I can visualize a situation where the money is due, the property can be attached, sold, and can recover. But appointing a receiver, directing him to manage, run the company, everything. I just wanted to know the source of power.
Well, only because for running the tea estate to liquidate the dues.
Sir, can it be done? I am just simply asking this question to you.
This I will have to check, my lord. I did not.
That is what in the last occasion I said that you'll have to show us the source of power.
Last occasion, my lord, your lord.
I am in doubt. The certificate officer can enjoin the power of a court in that sense, where it can do like a official liquidator, like a company court. It can say how you will run the company, how you will manage the company, how you will infuse the money, how you will do it. This is what is unknown to me, to be very frank.
Understand.
He will recover amount, whatever is left with the company. He can sell the assets of the company. He can sell whatever by a public.
He was not in a position to sell because this was a lease under the government.
I do not, sir. This is
The leasehold interest.
that is
for
a
the
different,
TSA.
sir. There must be a crop. There must be some finished goods.
That is why run.
No,
Okay.
not to run. Not to run.
Kindly see, mother. It says.
Not to run. I am still saying not to run, whether that power is there. Look at it. A very simple hypothetical example, sir. A money decree is passed against A. The money decree is put into execution
Yes.
by B, in whose favor the decree is passed. The court, the executing court says A is a company. I am appointing a receiver who will run the company. And the profit which he will earn, he will liquidate this particular decretal amount in this fashion. I am asking this, whether this recourses are permissible in an execution proceeding. He can attach, no doubt, under the code of civil procedure.
The form of
He can sell. This is not a attachment. What are you saying? Subject to any order that may be passed by the undersigned, you shall have all the powers necessary for management of the said business.
Then when
Under what? In accordance with the said schedule and the rules made thereunder. What is that? I just wanted to know what is the schedule and the rules which permits
Thereafter, your lordship will see,
Yes.
you are required to render due and proper account of your receipts and disbursement in respect of the business in accordance with part 7 of the income tax certificate.
I am just
proceedings.
I just wanted that it's a certificate proceeding, sir. What can be done in this regard? Show us the law.
Then I will bring
Shows
this.
the law.
It is in terms of the Income Tax Act, my lord, it has been done.
That can be done, but here the certificate officer is exercising a power on the basis of a certificate,
Yes,
and it's a public demand.
yes,
It's a public money under the Public Demand and Recovery Act.
yes.
Whether the certificate officer can go to that extent. That's a very simple question I'm asking from the day one.
But then I will also have to produce the previous orders passed by the Guwahati High Court in respect of writ petition challenging the orders of the Provident Fund authorities those were filed by the contributories. Contributories did not succeed. Ultimately, attachment and certificate proceedings then.
No difficulty. I'm again saying if there is a default, it's a statutory default, no doubt. One can recover.
Yes.
But whether the course which has been adopted is permissible under the law, I am asking.
My lord, if your lordship sees once on page 41, a typed copy is at page 42. This is the proceeding. This is
True. That is what I am saying.
recovery.
That recovery you are hereby requested to recover as the area of the land revenue
Then,
under
my
the
lord,
Public Recovery and Demand.
Yes.
Then-
Assam Land Revenue Regulation in place of Bengal Public Recovery Act. This
I am
is what-
asking, sir, this is what show us from that act that this power is conferred.
Very well, my lord,
I just wanted that.
I shall, my lord, I shall.
Show us the power, source of power. So you are a creature of the statute. You can't travel beyond these
No, I
provisions
cannot,
of the
I
statute.
am not saying, but the question today is, my lord, 2017, this order was passed. From 2017, the tea garden has reaped the benefits of my investment.
I
There
do
was-
not know from where you got it.
I have not usurped it. I have come on the basis of an order passed by an authority.
I understand, sir.
There.
Sir, a authority lacking inherent jurisdiction and
Yes,
power.
this is the same thing which is happening before this court.
I am asking you, sir. I am again asking.
I have followed your lordship's
So-
question. There is
So
no doubt
how
about it.
can such an authority do that?
Kindly see that today the question is if an act is beyond jurisdiction, it goes.
Then,
It is honest.
then,
I am not going to contest that proposition at all.
yes.
But what I am trying to tell your lordship is kindly consider this aspect of the
No,
situation.
no, you are more emotional. You are more sympathetic towards the employees,
No, I am not.
the
I am only
Provident
saying
Fund.
that this court
Very
is not doing
sympathetic.
the Same thing.
Sorry. I
I am only saying,
will go by the law.
yes. That is what I am.
I do not know whether the coordinate bench or a bench of lesser strength has said something.
But that
If
has-
I find that the law is something which is absolutely certain
Yes.
and anything done beyond the scope of the authority given in the law, we will not recognize. So show us the
Yes, I will, but only
authority of law.
one thing your lordship kindly permit me to say. By this appeal, I am only seeking to put at fault what has been done by the official liquidator. Official liquidator,
This is a very important question. If your authority or your appointment itself is per se illegal, and it appears that the official liquidator is the competent authority to take,
out, my lord.
this is what I'm saying. So first you show the source of power,
Very well,
then we'll consider.
I shall, my lord. Kindly give me 1 week.
If the company is an outgoing concern, is the company, then definitely the official liquidator will take over.
Official liquidator is
Take
not
over.
the owner. Property is vested in the state of Assam. This is a tea garden.
It has not wasted, sir. It is the lease which has been granted by the state.
The lease has expired.
Whatever, the
The
position
document
has
is
not been
valid till
reviewed.
2023.
Wait, he's talking a civil law. Let us understand the civil law. Even if the lease has expired, if the position has not been taken, then
then the official
Then
liquidator cannot sell it as his
I'm-
asset.
I'm again, that is his difficulty, what he will. He is an officer. He will have to seek whatever the permission and the orders which are required from a company court. You don't poke your nose into it. Let it be left to the official liquidator.
That has not
What
been
the
done.
official liquidator will do, we'll consider as a company court when it comes to us.
But the company code.
You can't say you are absolutely a stranger. You can't say, no, you have derived authority by virtue of this, page 36. We have to see whether this authority is legal or
But
this
my-
authority
my-
is per se illegal.
Yes, that is
That's
your
all.
lordship will say. But
And if it is per se illegal, then you can't, you are a stranger.
very well, but then I have on the principle of restitution, I will have a claim against the company.
That is a different, that is a
I
different,
will have-
whether you come into the order of preference, they will consider.
Yes, so that will also have.
So first thing is that what is the dues to the employees is the first preference under the Companies Act. We'll consider that.
I have paid the dues of the employees.
As whatever,
But have
I do
taken
not know.
recovery from company.
That is a more emotional, and you run the company, liquidated the profits, appropriated the profits. You have moved around everywhere. In an accounts, you have shown that you have gone there. This is the expenditure for
Well, that has
conveyance,
to be adjudicated.
adjudicated.
That claim has
Don't
to be
say so, sir. Mr. Singh, this is not so simple. You say, I have invested, I have done.
adjudicated.
You have also utilized the money. You are the beneficiaries of the money.
Return on my investment.
Yes, sorry, that you have done.
I will produce
expenditures-
all my accounts before your lordship.
নিজে ঘুরে বেড়াচ্ছে সব এয়ার ফেয়ার আমি গেছি সব ওখান থেকে ডিডাক্ট করেছে করেনি বলছি আজকে আমি আমার মানিটা কি হবে আই হ্যাভ ইনফিউজ ইউ ইউটিলাইজ দ্য মানি অলসো গেট আ বেনিফিট দেয়ার উইল কনসিডার দ্যাট
Very well, your lordship will kindly give me 1 week's time because these acts I will have to find out. My lord. It is not a very easy job.
find out. You also show us the law.
Your Lordship, the Assam Tea Employees Provident Fund Organization, they have submitted that there is an outstanding dues of 5 crore.
No, I
94 lakh
understand.
80,000.
I understand. This point which has been raised is you have to be ready on that.
Your Lordship, if your Lordship sees the stay application itself, they say that it is for a period of 5 years and that has expired on 1st March 2022.
You argue when he say lease expired. Then you argue that your term also
Lordship,
expired.
Not on the lease, but on their receiver, it was given. for 5
Oh,
years. Yes.
you don't understand. He is arguing the lease has expired. You can argue that your term has expired.
Your Lordship,
Both have expired.
pursuant to the notification, the lease has been extended up to 30th September 2023. It is valid
Yes.
and it has been sold. So what my learned friend is saying that the lease has expired.
That is
not
a
correct.
Lease has to be shown, my lord. Where is the lease? By a document, the lease cannot be extended. That your lordship will find out. The report must be there. Government has extended the tenure.
I succeeded up to the Supreme Court after a dissent.
I will not open my mouth in. terms
Ah,
of
I
leases and,
succeeded.
mortgages,
I
your
succeeded. You may argue this thing in case of a renewal, but cannot argue this in case of an extension. If you want to know the renewal and extension, then the first and foremost judgment I would request you to consider is Prabhas Chandra Dulais. And then in the case where I was there as the counsel, that is Nawab Datto, Ranjit Kumar Datto versus Tapan Kumar Shah. There was a dissent among the division bench, referred to a third bench, third judge, and then ultimately Supreme Court only on the ground of extension. And it says that it does not require any fresh document to be executed. In case of renewal, you are correct.
I will be saying this is the case of renewal.
No, she says extension.
It is completely, it has come to expired by a flux of time.
No, that is why I say you look at that judgment. And earlier judgment of the Supreme Court, 73 Supreme Court.
Very well, I should.
Read those judgments. Yes. on the joint prayer, let the matter be listed next
Next,
Thursday.
no, not this Thursday.
Thursday week. Next Thursday means I think Thursday week. Thursday week. Thursday week. না ছুটি পড়ে যাচ্ছে না থার্সডে আজকে তো হচ্ছে তোমার 8 তারিখ থার্সডে উইক 17 তারিখ হচ্ছে 17 হচ্ছে 17 18 yes 18 yes 18
The provident authorities have, provident fund authorities have not been made a party in this election. Person to which they are saying that they have got it, they have not made them a party.
I will serve a notice upon them.
do whatever you come ready on the point of law.
Mention.
We permitted to my lord mention one matter, my lord, appellate side, my lord. Or it is
Over.
my lord, appellate side mentioning, my lord.
Over.
My lord,
Be permitted in the morning. You know, you are you frequently appear. We don't make any distinction between original side and appellate side. No mentioning is over.
as your lordship, please. As your lordship, please.
Item number 1. My lord, I am for petitioner and correction needed on order dated 26/4/2023. It was petitioner number 5 was to be a strike off, but petitioner number 1 has been a strike off.
Which for the other side, where is Mr. B.R. Das K.K. Ghosh? Where are they? Have you given a notice to them?
No,
Why? You are seeking a correction. This order was passed in their presence. Is it not necessary that they should be here? You mentioned for correction and unilateral correction.
the last date, the order was passed.
Sir, in their presence.
By-
Will you not give a notice that there is a typographical error? We will mention the matter for correction of the typographical error. If they come and say, yes, it is, no difficulty. If there's dispute, then,
Yes, my lord.
and on your unilateral submission, the court will pass a note. Bring them, give a notice.
Okay, my lord.
Not today. I know it. That's why আমি বললাম আমি জানি যে এটা হয়েছে ওইসব
Item number 2, I am for the respondent. I am for the respondent, my lord. But no, I have not yet received any brief.
Where is Mr. Bharat Bhushan? He is for the petitioner. Which order they are selling?
Actually, I have not yet received any brief, my lord. That's why I seeking at least 2 days accommodation, my lord. Actually, there is what I heard that there is a contempt proceedings or incidents. Tribunal has not hold the contempt proceeding against that order. WPCT has been filed.
The contempt proceedings
Yes, ma'am.
that has been dropped.
That
Hello?
is- the contempt proceedings has been dropped.
Yes.
My lord, I have instruction to the clerk of Bharat Bhushan that he is paying for not today, my lord.
No, sir. First 25 matters we don't allow. There is a special note.
That's why I have seen.
Yes, there is yes.
I've
We
seen
say that
First
unless you
25
circulate a notice 48 hours. No, we can't. Can't do it. Dismiss for default. Record their appearance.
But I have been told one Mrs. Hongjukta Bhattacharya is appearing for the petitioner. Due to her illness, she has not come. She has not come today.
Since when she is ill?
But she has not come due to his illness, due to her illness.
Since when she is ill?
From her clerk said from yesterday.
Who is for the other side? Since an accommodation is sought on behalf of the advocate and record of the writ petitioner, on a ground of illness, let this matter be listed in the combined monthly list of cases for the month of June 2023.
I mean, little bit difficult situation today, my lord. By the impugned order,
Just 1 minute.
But I'm for the state in this matter led by Mr. Raja Saha. But only difficulty is, my lord, only one copy we have received, which is lying with Mr. Raja Saha, my lord. Due to
This is your internal
personal-
problem. You can't take an adjournment in this. Yes, where is the impugned order?
but
I
impugned
do
order,
not find any impugned order here.
order of at 225, my lord.
Yes.
Page 225, my lord. We have next.
Why don't you include the certified copy? Is no certified copy included?
No, leave was granted to file it possibly, my lord, without certificate.
No, there is no leave, sir.
In the back sheet,
Yes, back sheet I am looking at. There is no leave
Okay.
granted.
may I check, my lord?
আপনার ওখানে আছে? Nothing. How can you file without the certified copy?
But may I check, my lord, once again?
Yes, look at it.
No. লিখতে হবে, কেন? তাহলে? But in fact, my lord, the order passed by the tribunal, my lord. My lord, by that order, my lord, the tribunal, my lord,
First, cross this hurdle.
that's my lord. We are in fact not challenging the order of tribunal, my lord,
Then what do you want?
because the tribunal has passed an order.
Then what do you want? Tell us. You
Right.
are not challenging an order. Then what do you want in this?
Because my lord, I have no remedy, that's why I am before the writ court, my lord.
For what?
Now, the tribunal has said that we cannot hear the matter until the division bench is formed, my lord.
Yes.
But by that order we cannot be aggrieved, my lord. It's the duty of the state to, my lord,
Yes.
upon me, my lord. But by this time, my lord, the recruitment to the post of constable, my lord, the result has been published, my lord. And my lord, there was an interim order of this honorable court, my lord, by which, my lord, I was of the, my lord, tribunal, my lord, by which, my lord, I was permitted to participate in the, my lord, the selection process. My lord, the result will be published, my lord, with the leave of the court only. Now, my lord, the tribunal cannot grant that leave until, my lord, the division bench is formed, my lord. Therefore, I have become.
We are granting leave, no difficulty. If we grant a leave, what is the difficulty?
No difficulty, my lord.
Publish it.
Yes, my lord, we shall publish the result.
And you are the petitioner there or respondents?
Petitioners.
My lord, here only 10 petitioners came, my lord. Here only 10 petitioners filed this application.
And what about the rest?
My lord, rest are not possibly qualified. Possibly they are not qualified. Possibly they have not come.
But are they not entitled?
Yes.
To a
They are.
notice?
They are.
So
Most certainly.
Have you given a notice?
So far, my instruction is
Have you given a notice?
No, my lord.
Have you implemented them as a pro forma or a party as a respondent? Sorry, that defect is
Right.
bad for non-joiner of necessary parties.
My lord,
Order 1, Rule 9, we
Yes,
can
yes.
dismiss the writ petition.
my lord, kindly grants us leave, my lord, to add them party, my lord. This is a curable defect, my lord, kindly.
Curable?
With the leave of the court, I can always select.
Why curable? Why so, I would say, reluctant in this regard?
No, it's not. I'm very frankly, my lord, I make this submission, my
No,
lord. These people, my lord, they are unemployed, and what I cannot
that
say.
means the law has to be changed.
No, most
Then,
certainly.
then
That's why, my lord,
that
I'm
if
saying
we
that
can approach
I cannot say something that which is the result.
Nothing.
my lord.
and he has engaged the counsel like you and then say all
But
unemployed.
I'm doing this matter pro bono off the record when I can say this. For these people,
Anyhow, when you say I can't disbelieve it, but it's hard to believe.
that I am doing that FU.
Then I don't know. Leave is granted to the petitioner to add the left out parties as respondent in the instant writ petition here and now. The petitioner is directed to serve the copy of the instant application upon the aforesaid respondents by speed post and shall file the affidavit of service on the returnable date. List the matter on
70-80 petitioners are there, my lord.
My lord, may I file a type copy of the cost title? My lord? Otherwise, my the space may be, my lord, is very limited.
include whatever the party on the reverse side you have to include.
I follow.
Yes, let this matter be listed on 17 in the supplementary list. Yes. 17th May.
My lord, here, my lord,
By
two documents, my lord, I am annexed. That documents is wrongly annexed, my lord. Instead of MA, my lord, OA, my lord, I am annexed. My lord, that, my lord, kindly leave granted so that I can
will consider it. What is the nature of the order?
urging nature, my lord. I am
Challenging
waiting, my lord.
order of 8th February.
Yes,
You are challenging an order of 8th February. Just give us 30 seconds time.
8th February, my lord. They
Just 30 seconds time.
ওইটা তোমাকে অ্যানেক্স করতে ভুল অন্য অ্যানেক্স করে দেওয়া হচ্ছে ফেব্রুয়ারি অর্ডারটা নেই তো আমার কাছে সেটাই তো আমারও তো অ্যানেক্স করে দিয়েছে ভুল করে আমার কি হয়েছে এমএ না করে ওয়ে করে দিয়েছে এমএ হচ্ছে যে available নয় বলে
Where is the order dated 29/6/2022?
29/6/2022. My lord,
Yes.
kindly see this order. My lord,
I just wanted to look at
22, my
that
lord.
order 29/6/2022.
6/2022, my lord. My lord, 29/6/22, my lord. Regarding my lord issue, my
Disposing
lord,
of the contempt application, please
Yes.
show us.
that's order, my lord.
Sir, I wanted to look at order dated 29/6. Sir, are you not understanding?
Yes, yes.
I have gone through the order. I know what you want to say. Which page?
That has not been supplied to me. The may I tell your
My
lordship,
lord,
yes, paid for,
Please, I have gone through. The original order was challenged before the division bench.
Yes.
Division bench set aside that order.
was this
In the
order.
meantime, the contempt application was there. It has been disposed of. After the setting aside of the order, they approached the tribunal that this contempt order cannot survive once the order is interfered by the division bench. The court has said that this order is passed. Tribunal has said passed by a division bench. I can't recall orders sitting singly. I know.
Yes.
Don't say. I was not saying so much.
your
I
lordship,
simply asked, where is an order of 29/6? I just wanted to look at what was the direction passed therein.
My lord, just now I said.
Just 1 minute. Look at it. Division bench order. I wanted an order passed in a contempt, sir, 29/6. By which the contempt application was disposed of, sir.
Yes. My lord, it relates to already, my lord.
I
first-
want that order, sir. Was it a simpliciter dismissal or discharge,
Simply,
or it was certain more directions have been passed therein? I just wanted to know that. Please, sir.
yes. Joseph,
শুন, একটা পাতা দিয়েছি, বাকি পাতাগুলো নেই। কেন? সে এবার কি করে?
I am impaneled in 2011.
What is this? But where is the first page of the order? You are relying on this. Where is the first page of the order? What is the date of this order?
29th June 29.
I do not know. No, High Court order.
High Court order, my
First
lord.
page is, please look at the
High
first
Court order,
page.
my lord. 80, just now I.
Yes, you are given. Where is the first page of the High Court order?
High Court order. First.
ওরা কেন দিয়েছে না? দেখি 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 দেখি।
একই না দিয়ে দাও ডেটটা পাচ্ছি না কোন ডেটে হাইকোর্টের অর্ডার প্রথম পাস
Entire certified copy, my lord. This one, my lord, entire certified copy. My lord. Yes.
আমি প্রবলেম এখানে হচ্ছে দে আর নট ম্যাচ
Entire certified copy, my lord.
ম্যাচ দি ফ্রিকোয়েন্সি prevalence.
I also, my lord, not. That's why, my lord, I. Entire 85, my lord, WPST, my lord. আমি তো বলতে পারছি আপনি 85টা খুললেন না একটাই ডেট আছে 85টা খুলবেন 85টা খুলে একটাই ডেট আছে
WPST 85 of
একটা প্রথম ডেটেই ডিসমিস অর্ডারটা ডেটটা তো নেই
WPST লেখ না WPST 85 of 2020
WPST 85 বার করলে তো বেরিয়ে যাবে অফ 2023 2022 2022 16th August 2022. My lord, order dated 16th August 2022. Limited back on the. Then, my lord, I was Yes, yes. my lord. That's why, my lord, I came before your lordships. Content, my lord, recall this subsequent order. Subsequent, when my lord quashed this order, 20. Impugn order. Yes. My lord, fact, my lord. The matter is taken up the single bench pursuant to the order. My lord, kindly. That's order is not here, my lord. So, my lord. Yes, my lord. That's why, my lord. I just why, my lord. I am telling them, my lord. I am annexing that copy not annexed instead of MA OA, my lord. I am OA annex this document. So. MA, yes, my lord. MA. I am MA. Now the annex the OA. 105. That copy is not annexed. Yes. No, আমার কাছে নেই এটাই আমার কাছে নেই
এটা দেখো না
এটা ওয়ে আছে
no it is MA 105
yes this application is yes this is the application, the prayer for recalling of the order dated 29th June 2022, such as CCP number 72 of 2014, in which the contempt proceedings were heard and disposed of. Submission, Mr. Alam, is that since the Honorable High Court had set aside the tribunal's order dated 16th August 22 passed in way number 287 of 2010, therefore the tribunal's order dated 29th June is infructuous and thus need to be recalled. Any contempt proceedings be heard afresh. That is the order is to be
order after this it was not a foundation of the government. And you want to revive it was one that which accepts.
I am on, my lord. I am on, my lord. Kindly see the order dated. My lord, tribunal's order, my lord, kindly see. My lord, kindly see this. My lord, very, very unfortunate lady, my lord, is 10 years, my lord, is suffering this way or that way, my lord. Kindly see this order, my lord, page 32. Page 32, my lord, kindly see this order. Page 32. Lord, আমার একটি সাবমিশন ছিল
Which matter?
এই কেসটা
Which matter?
FMA 3432 of 2015.
ওটা তো আজকে আছে? নেই, then
এটা
No,
যদি
no.
স্যার একটু দেখতেন
আমাদের
কটা
কাছে
কোর্ট
কিছু নেই।
ঘুরছে আজকে বলছে এই কোর্টে হবে এটা
No, no,
কোর্টে একটু রেখে দিচ্ছি
কি আছে?
আমি ওল্ড ম্যান স্যার একটু দেখুন
Anyhow, ঠিক আছে, উনি জানেন না মেনশনিং কিভাবে করতে হয়, কি হয়, জানি না, বাট এটা কি আছে?
আমি সুপার সিলেক্ট ছিল 2015 সালে অর্ডার হয়েছিল হিয়ারিং তারপর থেকে হয়নি ঘুরছে কোর্ট কোর্ট
এটা তো এখানে হবে না। It is, what is this? Is a matrimonial, এটা ম্যাট্রিমোনিয়াল কেস।
না না না
তবে হাজবেন্ড বলছেন
এটা আরবিট্রেশন সেকশন 34 এ এটা প্রেফারেন্স করা হয়েছিল আলিপুর কোর্টে
আরবিট্রেশন ম্যাটার।
সেটা এফএমএ হয়ে এসেছিল 6 নম্বর কোর্টের
দেখি এটা আরবিট্রেশন আছে, দেখো
অর্ডার তারপর আর হয়
just find out. Anyhow, yes, call the next matter.
ওকে স্যার
6.
I am for the respondent, my lord, applicant in the way.
Who is Mr. Rabindranath Bag?
Mine.
Where is he? এটা কেন দিয়েছো আজকে?
That this matter was mentioned before your lordship with notification to Mr. Bag.
ও আচ্ছা, list on 88.5. The matter was mentioned citing an urgency. Stop. Full stop now. Citing an urgency, comma, but at the time of taking up the instant matter, there is no representation on behalf of the petitioners. However, the respondent is represented. Since the counsel for the petitioner is not has not responded when the matter is called on, it does not appear that there is any urgency in the matter. So let the matter go back to its original position and be taken up serially.
My lord, my client will die, my lord. He has already undergone a.
You mentioned or he mentioned?
I mentioned, my lord.
Oh, sorry. You mentioned. Did you give a notice to them?
My lord.
Where is
He
that
received
notice?
the notice. He received the notice.
Where is the notice?
My lord, on 2nd of May, I sent the notice and it was received by him. And I mentioned it on 3rd of May.
None appears on behalf of the petitioners when the matter is taken up today. Record his appearance. The writ petition is dismissed for default. Interim order, if there be any, stands vacated.
My lord, it was also earlier dismissed for default due to his absence.
Let it go. Let us see the next day. Yes. Call the next matter from the combined list.
My lord, earlier the matter, Sardar Amjad Ali, my senior, was present there. He went to Delhi for medical treatment. Kindly give it after vacation.
So why you did not circulate? When he went, must have gone earlier. We have said that the first 25 matters, unless you circulate a notice 48 hours before, no adjournment shall be granted. Why you did not circulate, sir? You would have sent the notice to the other side that I am praying for an adjournment.
Today the appointment was.
Sorry, we are dismissing it.
After vacation.
No, we have to be very, I know we are very strict in this regard, but we want.
Earlier occasion is mentioned, sir.
Yes,
Earlier occasion he mentioned in this matter, Sardar Amjad Ali.
he mentioned us.
Earlier occasion.
What do you want?
After vacation.
on the prayer of the petitioner that Mr. Amjad Ali, the learned advocate appearing in this matter, is indisposed. Stop. In view of the above, let this matter be listed 1 week after the reopening of this court following summer vacation. Yes. 79 কি হয়েছে? No, nobody. Dismiss. Next.
I beg to appear for petition. My lord, item 80, kindly the matter be taken up with 103. But I
First
was the
you-
same petitioner, my lord.
First you move 80.
It is related with item 103 regarding promotion, my lord, that was not given. In case of now I have designated as superintendent engineer. My next higher post is chief engineer. That chief engineer was without assigning any reason, that promotion was not extended in favor of me. Although at least 20 to 25 candidates superseded me, which is apparent from the gate. And the second next higher post is engineering chief. And during that time, one departmental proceeding was initiated, which was disposed of by imposing censure. So, my lord, 103 kindly be taken up with this matter. The main issue is related in 103, where I sought for promotion. And in this petition matter, I have challenged the order passed by the disciplinary authority, which could have been a bar
What
to my
is
next
the
promotion.
what is the date of that order? 103. 103 filed a bar code.
WPST 26, my lord.
What is the date of the impugned order there?
It is 7th February 2023.
7th February
2023.
2023.
Actually, my lord, I will retire on 25. At least, your lordship very well known, at least 1 year prior to the date of retirement. But
Let us see. I have seen that order of 8/4/2023 as well.
Yes, my lord. Well, that is the problem. Your lordship very well
No
known.
problem, sir.
The only one member.
No
is
problem, sir. Why you gave a consent that this matter to be taken up by a division bench? That's a consent which is recorded.
here.
You
That-
yourself.
That is admitted. That is admitted, my lord.
So if you
There
decided,
is no
gave a
division
consent,
bench, but there is no
Sorry?
division bench, my lord.
and no division bench, I know, then why you gave a consent? There was a part heard already. He was continuing with the hearing. You say complex question of law is involved, so let it be heard by a division bench. You yourself has invited. Otherwise, he was ready to hear out the matter.
May I submit one?
Sorry, we
one
can't do it.
submission out of the
No,
court, my
no,
lord?
nothing. Take it here. This is all. He proceeded. Heard part heard এখানে করা আছে। He wanted. বললো যে পরের দিন written submission আমি file করে দেবো। তারপর গিয়ে
No, my lord,
দিলো,
there
না,
is
না, না,
no
division
mandated
bench কে-
order from the single bench. That is why I gave that consent.
What? Sir,
No
that you
mandatory
can't,
order
sorry,
is
then
going
why
to-
you were aware that only one member is really functioning. And that one member, I must give them a compliment that he was just trying to proceed. He heard the matter
Absolutely,
in part.
absolutely.
And the next day, the council says that I will give my written submissions, no difficulty. The matter could have been disposed of. Then you both of you say, no, it should be heard by a division bench. You can't make a complaint now.
I'm not making any complaint, my lord.
Sorry, let it be heard by a division bench.
My lord, then my lord kindly specify time.
No, we will not.
At least 1 year, if the order will go in my favor, then also I will not hold the officiate, my lord. That is the problem.
What is this order? OIF 411.
It is a clear case of superseding. If you, my lord, kindly take trouble to
486. এটা অন্য দেখাতে চাইছে
my lord, kindly take up WPSC 26. My lord, kindly for 2 minutes, my lord. Kindly consider.
ফোন করে যাচ্ছে
Track na continuous.
Who is appearing for the other side?
I have served, my lord. Evidence have both the case.
এটা WPST 26 এ order করো that despite service there is no representation on behalf of the state respondents. Let the affidavit of service filed today be kept on record. It is submitted by the learned advocate for the petitioner that the petitioner is going to retire to produce the service book of the petitioner on the next date of listing. The petitioner is directed to serve a notice upon the government pleader who shall ensure the production of the service book on the next date. Such communication shall be made in course of this day, indicating that the matter would be listed on May 15, 2023.
Actually, my date of
Sir,
my lord.
let the service book come.
My lord.
Not so easy.
My
And so far as the next matter is concerned, present, dismiss. We are coming and dictating.
Next matter.
Item number 80 will be dismissed. We are coming and
Under compilation 79, my lord. Just enter the my lord.
Sorry, you did.
My lord is
Let
kindly
us come back. first.
my lord, before calling the list, your lordship, today is a day fixed for the state tribunal, my lord, but the WPCT matter taken up, my lord, and dismissed for default, my lord. We were in apprehension, my lord, that the matter would be taken on Wednesday, my lord. So we had a discussion, my lord, today, candidly discussed with Mr. Surjit Samanto, my lord.
No,
And ultimately, my lord, we derived that the motion would be taken up on Wednesday, my lord. If your
no.
lordship goes by the caption, my lord, in that case.
Item number 2 was WPCT.
Yes, my lord.
Where
It is not intentional latches, my lord. I was within the court, my lord, but
indicated
due to
that
the
supplementary list would be taken up. No, this can't be done.
it's a
No.
fault on my side, my lord,
No.
because I failed to understand what the thing is, but there's no intentional latches on my mind. It is a big matter, my lord. At least I shall not
What
be
is
able
a
to
big matter? There is
accountable
no big
to
or
my
small.
clients, my lord, because this is
All
complete.
matters are important.
No, my lord, I have to be accountable to my clients. Kindly consider, my lord, this. Kindly consider, my lord.
All good.
My lord, the
Kindly
same
consider,
issue,
my
my lord, the same issue, my lord.
I don't have any intentional latches on that, my lord. Kindly consider this, my lord.
This
79, my lord.
is the last chance.
Yes, my
Call
lord.
for it. Now, let-
79.
I beseech your lordship for the last chance.
yes, call the next matter.
Deeply
18.
obliged.
Come. The instant writ petition is directed against an order dated 6/4/2023. Passed in OA 486 of 2022 by the West Bengal Administrative Tribunal. Whereby and whereunder the matter has been directed to be listed before the division bench on the submissions advanced by both the counsels appearing for the respective parties. So the tenet of the order would reveal that the single administrative member was inclined to proceed with the hearing of the matter in order to secure the disposal thereof. But in the midst of the hearing, both the counsels submitted that the matter involves the various points of law, and it would be appropriate that it should be heard by a division bench. The moment the order is passed on consent, upon recording the submissions made by the respective counsels, we do not find any infirmity and or illegality in the said order. The order passed on consent of the parties or their respective counsels shall not be permitted to be challenged before the higher forum. Stop. In the event the either of the parties are of the view that such submission has not been correctly recorded, it is open to them to approach the same judge, inviting his attention in this regard. Stop. In view of the above, the writ petition is dismissed. No order is to pass.
Yes,
Call the next.
81, I am appearing for the petitioner. It- 80. My lord, it is a matter, my lord.
You are first tell us, sir. You are assailing an order of 26/7/2022.
Lordship.
Just give us 1 minute time.
Lordship.
চিঠি করেছি হুমায়ুন হিলসাকে চিঠি করা হয়েছে
কোনো ফ্রিজ বার
কোনো safeguard নেই, কিছু নেই। একটা presentation,
একটা ফ্রিজ
zero, কিছু নেই। সেটা দেখে তো বোঝাই যাচ্ছে। Challenge could change. The new name cannot be added.
না না সেক্রেটারি কোড অর্ডার সেক্রেটারি পাঠিয়ে দিয়েছে পিএসসি সেপ্টেম্বর 20 তারপর বুঝাতে পিএসসি
See, তোমরা যেটা নিউ পোর্টাল করেছো, verification চেঞ্জ আমার ডিপার্টমেন্ট।
Sir, what is the wrong in the order, sir? Rather, the tribunal has really activated the process.
Lordship, my humble submission is order was passed on 26.
Sir, the earlier order was that your grievance as to the consideration to a promotional post was concerned was taken up.
Lordship,
The authority found that yes, you have to take a decision.
Lordship,
They were very fair on the last occasion when they approached in the contempt. They say that we have already initiated, considered, we have sent to a PSC, Public Service Commission, because you are a Group A officer.
Lordship,
So their permission or their waiting is necessary.
Lordship,
The Public Service Commission was not doing anything.
Lordship.
Then ultimately the tribunal says add them.
No,
They-
no, my lord, that is refused. My
Not
petition-
refused.
My lord,
Just 1 minute.
Lordship, Lordship,
Then they say that the order was not passed on a Public Service Commission.
Lordship,
So they can't be held responsible for this. That was their stand.
Lordship,
The ultimately by an order of 6th of March
Lordship,
2023,
Lordship,
the court, I agree that the compliance was to the LS contemner and not. Therefore, a new name cannot be added now. Either the prayer is not allowed. I do not know what is this. Prayer of adding him. Oh, your prayer
Lordship, Lordship. That's
was
why-
not allowed.
Not allowed.
Wrong.
Lordship,
CWAT principles. On a CWAT principles, definitely.
Lordship.
You can't play with the court. Sorry.
We have sent it to the PSC on 9 September.
Understand. Then why you raise an objection that he should not be made a party? You have raised an objection. Mr. M.N. Roy, the learned counsel for the state, however, submits the direction was upon the LS contemner, additional chief secretary, Home and Hill Affairs, and not to the secretary, and therefore adding him as an LS country is not as per the tribunal's order. Why you raise an objection? Are you not aware of the CWAT principles? Even a non-party is bound. If he is aware of the order that he is to do, then he is bound. Then why you will not? Not correct. All the technical objection is projected upfront at the behest of the LS contemner, which has a far-reaching ramification in due implementation of the directions/orders passed by the tribunal. The tribunal was approached by the petitioner for consideration of his candidature to the promotional post pending a disciplinary proceedings against him. Initially, the disciplinary authority imposed a penalty of withholding 2 annual increments without future effect, which was modified and or varied by the appellate authority. That the penalty of withholding 1 increment of 1 year without cumulative effect should have been a proper stop. It appears from the stand of the respondent in the tribunal application that the reckoning date of such penalty as per the rules expired on 30th of June 2022, and thereafter there is no impediment on the part of the respondent authorities in considering the candidature of the petitioner to avail the promotional avenue permissible in hierarchy of the post. Based upon the aforesaid facts, the direction was passed upon the Additional Chief Secretary, the Home and Hill Affairs Department, Government of West Bengal, to consider the case of the applicant for promoting him to the rank of a Deputy Superintendent of Police within 8 weeks from the date on which the vacancy in such post arise. Alleging that despite the direction passed by the tribunal, there is a reluctance and or violation or a dormant attitude shown by the LS contemner in not taking a decision in terms of the said order within the stipulated time. It was a specific stand of the LS contemner in the contempt application that the case of the petitioner has been considered, and since he is holding a Group A post, an approval and or consent of the Public Service Commission is required, and in fact the file has been sent to the Commission in this regard. The matter continued in the docket of the tribunal, as on the next date of listing, this aforesaid submission was repeated and reiterated by the state, which constrained the petitioner to make a prayer that the public the Secretary of the Public Service Commission, West Bengal, should also be added as a LS contemnors in the contempt application. Curiously enough, the state took a vehement objection to such addition. Sorry, your counterpart. You can't shy away from the responsibility. Took a কি বলেছি? Vehement objection to such addition on the score that since the direction was restricted to the Additional Chief Secretary, Home and Hill Affairs Department, the Secretary, Public Service Commission, West Bengal cannot be roped in the contempt application. On the ipsit dixit of the aforesaid submission, and without considering the other aspect, the tribunal proceeded to reject the prayer of the petitioner. As a resultant effect, the addition that as a resultant effect, the Secretary of the Public Service Commission was not permitted to be added as a party. Stop. So it is not a hard and fast rule that the parties to the proceeding can only be arraigned as a party in a contempt application. Even a non-party being aware of the order and or a judgment passed by the tribunal or the court can be added as alleged contemnors if their role is intricately related to the implementation of the order passed by the tribunal or the court. Mere passing the buck cannot defeat the substantial justice to be imparted to the litigant. And the moment the technical plea is pitted against the substantial justice, it is a latter which must prevail. The sea-vault principles can also be activated, well recognized in a contempt jurisdiction, where the non-party can be held responsible for the violation and or non-observance of the order passed by the court. Stop. We therefore do not concur with the decision of the tribunal in this regard. Stop. The impugned order is set aside. The Secretary, Public Service Commission, West Bengal, is impleaded as an added LS contemnors in the contempt application, being CCP 97 of 2022. Stop. The petitioner is directed to serve a copy of the contempt application upon the added LS contemnor. Copy of the contempt application bolechi to added contemnor by tomorrow, and shall file the affidavit of service before the tribunal on the next date.
What is the public holiday?
It further appears.
What is the public holiday? Tomorrow is the public holiday.
The post office is also holiday. So you have to tender the copy in the post office. বলেছি by speed post করে দাও, service by speed post. That no date has been fixed by the tribunal.
Not 18/8 has been fixed on
In an earlier order.
7 February order, 18th August, my lord.
But this is the order subsequent thereto.
Not
Since no date has been fixed by the tribunal in the impugned order, but our attention is drawn to an earlier order
7th February.
passed on 7th February 2023, where the said contempt application was directed to be listed on 18/8/2023. So liberty is granted to the petitioner to pray for preponement of the said date after the service is effected upon the alleged added contemner. And the tribunal shall make endeavor to prepone the date and shall see that the contempt application is brought to its logical conclusion at an earliest.
A time में क्यों
No, sir.
मैं काहे की
No, sir. SEAWALD.
I'm grateful.
Let's call the next.
I am for the petitioner.
Lord, I appear in this matter for the respondent.
State.
I am for the state.
Call.
Lord, I have challenged an order dated 15 June 2022, which is at page 217 of the writ petition.
It gives a very bad impression. The authorities cannot do something backdated. That gives a very, very strong presumption and apprehension in our mind that everything was done predating. If the order was passed on 12th of February, May 2021, what was the constraint that it was only served in August 2021? May, June, July, August, 3 months. When it was dispatched, it was done through email. It was done through email. It was done through WhatsApp. It was done everything. Why? Why not on 12/5 itself? Or within a very close proximity of the time? That shows that in order to avoid it, something has been done.
My lord, it was first time, my lord, it was, my lord, served when it was taken up on 12th August 2021. It was taken up by the tribunal. My lord, I am on two issues, my lord.
One issue only.
One issue.
There was a specific direction to complete the disciplinary proceeding within 6 months. There was a default clause also indicated. The default clause was that if you cannot complete it, then the entire proceedings shall vitiate, means it will not be considered to be valid. You were conscious. You did not challenge that order.
But my submission is, my lord.
Now, if the default clause is there and it appears that you have not completed it, probably, you have shown that you have completed within the time, but it appears it raises a very, very, very suspicion in you, in your action. Then in that event, the default clause will have no consequences.
But my submission is, my lord, no extension of time was required, nor, my lord, it was.
No, there was nothing, because it was up to June 2021. You have shown the order that you have passed the order on 12th of May. That is within the time. No difficulty. But since the communication was done on 19th of August, 12th of August, through WhatsApp, through email, that shows that it was passed much, much, much later, which is what the tribunal found. And just to cover up whatever the lapses you have done.
But my respectful submission before your lordship is that we have acted in terms of the direction passed by the tribunal.
Tell me then, what first question is, you have acted. It appears from the record, if it appears that you have acted. Tell me, what constrained you not to communicate this decision before 12th of August?
There was a COVID restrictions, my lord, at the relevant point of time, which was, my lord.
Sir, there was no COVID restriction when you initiated a contempt proceedings and you continue.
No.
What are you talking? The COVID is struck for the first time in March 2020.
Correct.
And proceedings was initiated even thereafter. You called him, second show cause, reply, hearing, everything was done after that.
Yes.
And in 2021, there was no restriction in that regard.
Service of punishment, my lord, was not the issue. And that is why my submission is, my lord.
Sir, service of punishment is not. The quantum of punishment is not an issue.
My lord, your lordship,
Only thing is, issue is whether you have completed the proceeding within the timeline or you have not completed the proceeding within the
we
timeline.
have completed it within 6 months.
Correct. So it appears that on 12/5, within 6 months, you did it 21.
Yes.
But you did not communicate it to it. That raises a suspicion.
That there was no such time limit, my lord.
Yes.
There was no such time limit. Your lordship, kindly consider page 21.
That is why that's your record. So you can do anything.
No, my lord, what my submission is, my lord, the direction of the tribunal, my lord, in the erstwhile litigation was very.
I am appointing a special officer here and now. I'll go to your office and will take all over these files. That there must be a noting when the file is placed, when it has gone there, everything has to be there. How the files have moved from one table to another, there will be a movement. Let us see the movements. There's a moment.
But your lordship kindly see the order of the tribunal. My lord, kindly consider, my lord, the direction. My lord, passed in OA 420 of 2020 at page 21. My lord, the relevant portion is at page 23.
Sorry.
My lord, may I place, my lord, page 23, my lord. Kindly consider page 23 once, my lord. That was the direction, my lord, passed by the tribunal. And my lord, whether, my lord, we have acted in terms of this direction, I
Sir,
can
there is no dispute because you have to see that we direct the respondent number 2 to conclude the departmental
Yes.
proceeding within 6 months
correct.
and to take a final decision. Then the question is another. In default, it is also indicated. In default, the proceeding should be vitiated.
My lord,
This is what they say, that it has vitiated because you have not done it within 6 months. But your order shows that it is passed in within 6 months.
my submission is, my lord, the punishment need not be passed, my lord, within the 6 months. Your lordship kindly consider the first direction of the tribunal. First direction.
What?
We direct the respondent number 2 to conclude the departmental proceeding within a period of 6 months.
Yes.
This is one portion.
Correct?
And to take a final decision, this is, my lord, should be read, my lord, disjunctively. And to take a final decision.
Why disjunctively? Conjunctively.
My lord,
And word.
the proceeding is one.
Sir, no, sir. That is what is a very important thing. Concluding the proceeding within 6 months.
That is
And while concluding it, you have to take a final decision by way of passing a speaking and a reasoned order as per the rules.
as per the rules.
And then say, communicate the same from the date of the receipt of the order.
My lord,
Now, the question is, these are all composite. These are all composite. These are all composite. You can't segregate it.
my lord, if I say, my lord, the plain reading of this direction is, my lord, if I construe it, that respondent number 2 has been directed to conclude the departmental proceeding within a period of 6 months. This is one part. Therefore, conclusion of the proceeding is, my lord, has to be done within a period of 6 months, and then to take a final decision by way of a passing
Sir,
a reasoned.
That means the proceeding is concluded within 6 months. The authority is waiting since 2 years or 3 years, according to you, 3 years, and then pass the final order by a speaking one, being a.
Within 2 months, my lord, we pass the.
Sir, I am giving you a hypothetical. The way you are interpreting the order, that means I understood how weird you can go. I can understand. Imagine your contention is first portion of the order which says you should conclude the proceeding within 6 months. So you have concluded the proceeding within 6 months. So far as passing the final decision is concerned, it is something different. There is no mandate that it has to be passed within 6 months.
Well, first of all, my lord, this is an order.
This is what you want. Sir, when a proceeding is concluded, tell me. It is not a hearing concluded.
My lord,
When the proceeding concludes,
it
it
depends.
depends.
Subject to the rule of the subject.
By
to
passing a final order, it concludes.
My lord, if an appeal is.
Sir,
referred
that
to
is a
the-
different, no. Please, there is a distinction between the proceeding being concluded and the effect of the decision is different.
My lord,
The moment the proceeding is concluded means that the final order is passed. Whether the final order would take effect immediately or from a posterior date, from a prospective date, or from a retrospective date, it is within the rules that you have to follow. So effect is one, conclusion of the proceeding is another. Here what the court says was, the tribunal says was that you have to complete the entire exercise of the disciplinary proceeding within 6 months, meaning thereby by passing a final order within 6 months.
In, my lord, this next phase of that direction.
And then the question is very difficult, very important. In default, then what is the meaning? It is the surpluses. superfluous. It was nothing. It has got no meaning at all. In default, the proceeding should be vitiated. What does it mean?
But in default, my lord, my respectful submission before your lordship is
ভাই দেখি তো কত weird হাইতে যেতে পারে, দেখি interpretative skill কত দূর পর্যন্ত যেতে পারে. Let us see.
today, my lord, this is the direction of the tribunal. If my lord, it is interpreted in a subsequent.
Sir, you are interpreting improbable, not at all appreciable.
Just my lord, the plain.
What are you
reading
saying?
of This,
This is a plain reading, is a very simple, unambiguous, very clear, explicit. The way you have read it, I think no prudent or a normal man would read it like that. It is a, I would say, unscrupulous person just to shed what he has committed wrong. If he comes with this weird kind of a notion after reading it, can't be held down. And the order of the tribunal or the court should not be read like a statute.
Yes, my lord, that is exactly my lord, my submission.
I'm saying, so any words cannot be stretched or interpreted like a statute. A
Exactly,
normal
my lord,
man,
that is my submission.
when he writes, you have to understood in this way. And there is a clarity in this, that you will conclude the proceeding within 6 months and reasoned and
My lord, and to
take a
decision.
final decision by passing a reasoned order. So final decision at the time that concludes the proceeding,
No such.
and by way of passing a speaking a reasoned order as per the rules, and communicate the same from date of the receipt of the order.
This is also meaningless. This is also meaningless because this and the same from the date of receipt of the order. If I
Because
put
sometimes
very
it so
fine-
happened that there is a higher authority. And the higher authority they communicated the decision, and then the office staff by a letter communicates annexing the decisions to you. He is merely, I would say, a messenger. And the order is passed by the disciplinary
with
authority. He
request
just
of respect,
communicates.
my lord, if we, my lord, interpret in this way, my lord, in a subsequent proceeding, my lord, whether this can be interpreted. When the plain meaning of the judgment says that conclude the proceeding within 6 months and then pass an order. It's a plain meaning.
What is the
of-
meaning of conclude the process? When the proceedings had been said to be concluded,
my lord, a
upon
proceeding-
passing a final order, it is again I'm saying, hearing should be concluded. I can
but
understand
normally,
that the
my lord, your
hearing.
lordship is absolutely
No,
correct. Passing
no,
of a
it is
final
not.
order.
It is not. Proceeding is to be concluded.
My lord, that is exactly, that is what your lordship is, my lord, saying is absolutely correct. Final order of punishment, issuance of the final order of punishment should be the conclusion of the proceeding. But when the tribunal says that you conclude the proceeding within a
Sorry.
period of 6 months and to take a final decision.
Lord,
We can't.
kindly see this, Lord, this is Lord, material suppression in the writ petition. They have accepted. There is no scope of interpretation, anything. They have accepted and they have issued a second charge sheet
No,
in
I
the
have
same
stated
line,
paragraph
which is
11.
also under challenge before the tribunal.
I have stated paragraph 11, my lord, on the self-same.
Kindly see this, Lord. They have
Why would I
accepted. The challenge
My
is,
learned friend
the
has not
challenge
read.
is meaningless. The challenge by way of this writ petition is meaningless. Because this is also under challenge before the tribunal.
Kindly consider paragraph 17. I have stated that on the self-same issues, my
No,
lord.
no, where he has interpreted?
Lord, this is dated, your lordship, kindly see this.
11, 12.
Yes. Quashed, they have accepted. Tribunal quashed the final order, the entire proceedings. They have again issued the charge sheet in the same line, which is also under challenge before the tribunal.
But only thing, my lord, by way of this, my lord, a person, my lord, against whom a serious allegations are leveled, my lord, he will be, my lord, go scot-free, my lord.
Taking aid of the interpretative skills, the state is sought to interpret the order passed by the tribunal in an earlier round of litigation. In such a manner which would frustrate and stultify the tenet and the import a man of normal prudence would gather. Challenging the disciplinary proceeding, the tribunal was approached. But the tribunal did not find that the disciplinary proceeding should be quashed or set aside at the nebulous stage, but found that there has been a procrastination of the proceedings at the behest of the state, and further directed the proceeding to be concluded within 6 months. And take a final decision by way of passing a speaking and reasoned order as per the rules and communicate the same from the date of receipt of the order. Being conscious that the proceeding may be lingered on, a default clause was incorporated in the order that if the proceeding is not concluded within 6 months, the entire proceeding shall be vitiated. Pursuant to the said directions, the disciplinary proceedings continued, and it is not in dispute that the petitioner participated therein. Sorry, petitioner means respondent participated therein. Yet the final decision was not taken for a pretty long time. Ultimately, a writ petition was, ultimately a tribunal application was taken out, alleging that despite the time limit indicated in the earlier order, and in view of the default clause, the disciplinary proceeding becomes non-est, which was duly admitted in the month of August 2021. Immediately thereafter, that is 12/8/2021, the petitioner received the purported order dated, what is the date?
12th May 2021.
And the WhatsApp and all, everything, 19th or 12th?
19th.
19th August. 19th August, 12 Noy.
Well, the order
19th
was
August
dated 12th
of
2021.
the order dated 12th May 2021. He received through
And 12th August 2021, my lord, it was served.
through email and WhatsApp. Full stop. The tribunal found that an attempt is sought to be made to get to wriggle out, not get to wriggle out from the default clause, the default clause having been incorporated in the order passed in the earlier writ petition.
Passed in the
And
original application.
and and quashed and set aside the said final order. A weird, the learned counsel for the state vociferously submits before us that the order passed earlier, the order dated 11/12/2020, passed earlier, has to be read in a manner that would not render the decision vitiated in terms of the said order. According to him, the word within quote "and" has to be read disjunctly and not conjunctly, so as to uphold the decision of the disciplinary authority. Stop. According to him, if the authority have understood and perceived the order, sensing that the word within quoted "and" has been used disjunctly, comma, the decision of the disciplinary authority cannot be rendered infructuous. Stop. We are afraid whether such impression can be gathered upon a meaningful reading of the language used in the order dated 11/12/2020. The tribunal did not use the complex or flowery languages which may be understood and or perceived by a man of normal prudence, as it is capable of having more than one meaning. Stop. The language is explicit, clear, and does not create any kind of an perceived notion into a man that the tribunal intended the disciplinary proceeding to be concluded by passing a final order within the time limit indicated therein. It is sought to be contended that the conclusion that within court to conclude the departmental proceeding within period of 6 months, unquote, has to be read as the conclusion of the hearing by the respective parties. For the reason that the further sentence within court to take a final decision by passing a speaking and reasoned order, unquote, has to be segregated and cannot be imbibed within the word "conclude" as appearing in the said order. We are not accepting the aforesaid interpretation, as the conclusion of the proceeding can only be done by passing a final order. Otherwise, the language would have been different. Full stop. A proceeding is concluded on a passing of the final order as any other interpretation would eschew the very purpose, would frustrate the very purpose, and encourages the unscrupulous litigant to interpret differently to avoid the default clause incorporated therein. The word within quote "and" is always considered to be in conjunction with with something indicated before it, and has to be read in wholesome to gather an impression and or intention of the maker of the said order. Stop. It is improbable and inconceivable that upon affording an opportunity of hearing to the respective parties would be construed as the proceeding being concluded when the order, final order, is not passed, keeping the fate of the litigation in lurch or in suspended animation for all time to come. The tribunal has found that the proceeding was not concluded within the time frame, and in order to overcome the strict consequence provided by inserting the default clause, the order was passed predating the same. Sorry. But the communication was made through the electronic medium much thereafter. Our attention is drawn by the respondent that the authorities subsequently accepted the order of the tribunal and issued a further memorandum dated 28/9/2022 proposing to initiate the inquiry afresh under Rule 10 of the West Bengal Services within bracket classification, control and appeal bracket close rules 1971. We find from the first paragraph of the said memorandum dated 28/9/2022 that the authorities have accepted that the proceeding could not be concluded within the stipulated time and therefore has been quashed. Stop. The moment the authorities have decided to initiate a de novo proceeding, disciplinary proceeding, having accepted the decision of the tribunal, the state cannot take a rebound or approbate or reprobate at the same time. Stop. From whatever angle we look at, we do not find any infirmity and or illegality in the impugned order. The writ petition is dismissed.
One thing, my lord, that is not the observation of the
ওটা
tribunal.
আন্ডারলাইন করে দাও, বোল্ড লেটার্সে লিখে দাও। যে জায়গাটা বলেছি না যে একদম প্রিডেটিং ইট, ওটা বোল্ড লেটারে করে দাও। Has to be done.
Great.
I'm mentioning one urgent matter. Lord, the
Not
matter.
at 2 p.m.
This is extremely urgent matter relating to 10C of the West Bengal School Service Commission Amendment Act. New matters have been assigned to your lordship's bench. Already Mr. Subir Sandal mentioned your lordship's allowed his prayer.
It will appear, it will take it up.
State my lord the tomorrow or otherwise my lord the
Sorry, we can't say. Let us see. This matter is assigned to us and this is a war at the verge. Let us start.
Tomorrow, day
Yes,
after tomorrow.
let us see. Yes.
The appeal before your lordship, I just reading out the names first. Shandip Ghosh, Saheb Das, and Sukumar Kormakor. Now, the incident happened on my lord 17th September 2006. Now, my lord, the victim was in the house, the mother, my lord, with the mother. And it is the case of the prosecution, it has come out in course of investigation and the my lord, thing, my lord, that Saheb and another person had come to the house and had taken him by a two-wheeler. This is the, my lord, evidence of the mother. So, my lord, Saheb had and another person had taken in a two-wheeler from the house, the victim. The mother had seen them. The mother, my lord, had also seen the motorcycle. Now, this is corroborated by a chance witness, that is with PW14. Now, PW14, my lord, had gone hostile, but that part, my lord, which he had stated in 161 as well as, my lord, in the deposition, that he had seen Sukumar and he did not see Sukumar, but he had identified Saheb and another person. This part, my lord, corroborates with the mother's evidence. My lord, in the cross, your lordship will kindly see. May I take your lordship to that? My lord, I will be a bit slow because I am physically handicapped a bit. I'm physically a bit handicapped, my lord, so your lordship will kindly take me on this.
Why handicap?
Because I'm carrying a stone in my gallbladder. So I can't stay hungry, I cannot overload also. And when the pitch starts, my lord, I have to rush out without making a scene. Now, my lord, may I just take your lordship, my lord, to PW. First, I'll take your lordship, my lord, the mothers at page 21. Now, my lord, your lordship, from the first paragraph, it starts with one. On 17/9/2006, I was present at home and also my son was at home. On that day, his father was not at home. Saheb and another man named Sukumar Kormakar came to our house by a motorcycle. Sukumar Kormakar came to our house by motorcycle bearing number so and so. They wanted to take son with them, but he did not want to go with them as he had some work at our house. On their repeated request, my son went with them, telling that he will come back within 1:30. Saheb was driving the motorcycle. My son was sitting behind him on that motorcycle, and another man, Sukumar, was sitting behind my son on that motorcycle. Now, my lord, if your lordship will kindly now, my lord, come to the person who had the other person who had seen him, seen the journey. That, my lord, is page 83. Now, he is, my lord, Sheikh Munna. The relevant portion I would like to place before your lordship is they are about to Jasur Road Jessore Road, the motorcycle was driven by Sahib and by another person
Which page?
at page 83, towards the bottom.
Yes.
The motorcycle was driven by Sahib and by another person. As pillion rider, Bapta was middle in the motorcycle. So, my lord, he also corroborates that there were 3 persons on the bike he had seen. Now, 2 persons' identity has already been disclosed. And, my lord, the mother, my lord, PW2, had filled up the thing of Sukumar. Now, this, my lord, witness had become hostile and we had cross-examined him as on the prosecution side, my lord. And also by the defense, my lord, at page 85. Cross for all. Cross by all. Page 85. I met him once for payment. I have no trade license for repairing work of stuff. Not a fact that Bapta was not going by motorcycle with Sahib on 17/1/2006. So, my lord, this is an affirmative. Not a fact that at the time Sahib was not driving the motorcycle. Not a fact that Bapta did not ask me to meet him at 619 Green Park. Not a fact that I identified Sahib as per instruction of police. Not a fact that I did not use to work repairing sofa, my lord. Not a fact that Bapta did not arrange dog show at his house. Not a fact there was no quarrel between Bapta Sahib over the dog. Not a fact that I deposed falsely as per instruction of the police. And nothing. This is binding on. Now, apart from this, there's no cross-examination at any other point. Now, my lord, I will take your lordship to PW5 at page 44. So, till now we have seen, my lord, now the deceased is in their hand, had left home and they're in their hand. Until unless they can show, or they could make out, they have tried to make out a case that during their, when the victim was in their hand, the victim himself had consumed alcohol, my lord. That part I'll come later. And he fell down from the thing. And it is they who had taken the victim to the hospital. So, my lord, they were having the custody or in their possession of the victim all throughout. After 11 a.m., my lord, when he had left.
The question which really falls in this criminal trial, you are trying to project that, yes, the victim was last seen together and they were driving, they were just riding on a motorcycle, and they went there. Now, 2 stories that has come up. One is that he fell from the roof of that particular building where they were flying a kite, because that was Viskarma Puja day. And the second story which we found was that he fell from a cot. He was just sleeping and then he suffered an injury.
That was the first information given.
Whatever. There are 2 stories that have come. Question is, sometimes the last seen theory is one aspect and the commission of an offense is another aspect. If it is proved beyond health, that this injury was caused by any kind of a weapon which is being used, In this case, there was no sharp weapon which was used because there is no cut injuries or something in the on the body. A theory goes that there may be a blunt weapon which was used. Blunt weapon was never recovered. The police could not trace out, could not retrieve that blunt weapon. Now it is all on the basis. First thing is you have to satisfy us from the evidence. Yes, this death was caused with certainty by use of any external force or by use of any kind of a weapon. If there are two probable stories that comes out from the doctor's evidence that this injury can be caused by falling from a height, say a greater height, then in that event, simply on the basis of a last seen theory, can we link the chain? Because it is all dependent upon a circumstantial evidence. There is not a direct witness or say the eyewitness who have seen all these incidents that's happening and that caused the death. Everybody has seen, yes, we have seen together. They were together and they have gone. I think shows the law on this subject that on simplicity or on the last seen theory,
I'll let you go.
a prosecution can proceed.
May I just first hmm? No. No.
Yes.
Now, my lord, here the last seen theory, as I see, which is not been, my lord, controverted by or contradicted by my lord the defense. That is taking the victim from the house to.
That has come.
Now, my lord, what has happened after he was taken? Now it is they who tried to build up a case first by informing the mother that your son has fallen from the cot. The mother has not been arrested. She's absconded. But yes, but the other witnesses also say, yes, the information. Now, my lord, it is from theirs end. One of the appellant acting as a guardian, my lord, had admitted him in a hospital. Had made all attempts to admit him in various hospitals and at last, my lord, in CMRI. So, my lord, the victim was all the time after he left the house, he may have reached the house of Sahib or may not have reached.
No, he has reached because the incident took place at the house of the Sahib.
I am grateful.
No difficulty. Why you are raising a doubt? There is no doubt.
No.
There is no doubt in this regard that all the incident happened in the house of a Sahib.
I'm grateful. Now,
two things that comes. So far as a Sahib was consistently named by all the witnesses because he was such a known person to everybody. Everybody has pointed out. Now there was some kind of a confusion so far as another person as a pillion rider. So far as a Sandeep Karmakar, Sukumar Karmakar, who was said to be another person, a pillion rider, I think the mother has named, the hostile witness has also named. So far as a Sandeep Ghosh is concerned, I do not find anywhere except his identification in the courtroom.
No, your lordship, my lord, what has happened is this, he acted as a guardian while admitting him.
Oh, no, that's true. That's true. Does it mean there is a commission of an offense by him? Cannot. Question is that who were the persons who really committed an offense which led to a death?
Now, my lord, your lordship will kindly see because this has been done by the group. Section 34 is also there. Section 34, the charge. So, my lord, they had severally had done this, their role.
No, section 34, I understand. If now the question would be another, whether he has played any active role he has played anything, because the question is whether there was any commission of an offense at all. The first and foremost question which rises, or it was a sheer accidental death. There are two things. If it is an accidental death, one cannot say. If it is a commission that somebody has committed an offense and that led to a death, then his role attributed to the commission of an offense has also to be made out. That somebody has seen, or somebody is there, that he was a person who have taken an active role under section 34 also to robbed him under section 34. One has to make out a case like that.
Now, your lordship will kindly see, if someone, my lord, has tries to make out a case himself, that yes, I admitted him by posing as a guardian.
Correct.
Now, my lord, that is an admitted position.
True.
He is not denying that.
No, that is there because the document shows that who were the person who signed as a witness, who were the person who disclosed themselves as a guardian or something. Those documents are there.
So, my lord, his presence in the PO will not be ruled out.
But does it mean that he has played a very active role in the commission of an offense? A person who has fallen from the roof,
No, that part I'll
and
complete.
if somebody sees it, out of that, just to save the life, somebody played a very important and active role in taking him to the hospital. And then a person who has done on a humanitarian ground, and then you say that you are also responsible because of the fact that you were present.
No, here the question of only presence in the PO is not the, but the fact.
Even a presence in the hospital is not that important.
He, my lord, had tried to mislead even the hospital by giving a wrong name and wrong address. And a person like my lord, who is unconscious, who had a injury on the head. He's not taking a person who has just been suffering from some ailment or a road accident. He has been just immediately carrying him and trying to save life. He has taken to help his friends. The two friends, knowing, my lord, that what has happened. If you would have gone and reported the police, even after admission or attempt of admission, that well. Because why did the hospital first refuse to take him? They suspected it was like it's a case of unnatural happening. Now he insists that yes, this is my name, this is the name of the patient, wrong name, wrong address. He has taken upon himself. Now he has to prove it. In 313. He did not say anything. When court has given him an opportunity.
Law of evidence, I do not
No,
know.
I'm not.
I recognize it as a reverse principle or kind of a rebuttal of principle, the presumption. Sorry, a reverse presumption or a rebuttal of presumption. You have to prove it.
I have to prove it. To the extent, my lord, it is in the evidence are in my hand. But if, my lord, someone takes it upon himself, special knowledge. Yes, he knows what has happened because he is trying to admit
everywhere in that sense. I think probably section 106 or 7 of the Evidence Act. Special knowledge. Then in every case this is special knowledge theory.
The facts of the case, but the facts of the case, my lord. The facts of the case, because my lord, he is taking a person like who is not well, who's my lord not in a state of mind to speak.
It would have been a very open and shut case, Mr. Negi. Had that victim being conscious, it would have been an open and shut case. First thing is, there must be a declaration, some statement made by him. And if he says that this has happened like this, then section 32 of the Evidence Act, to that extent one can. But he was unconscious. He was not in a position to divulge.
Because he was assaulted in such a manner, he was unconscious. Now, my lord.
I was just thinking, that's why you have to segregate it. Sahib, constantly, everybody hammered.
No,
No difficulty.
Sukumar also, your lordship, because he is the person who
Sukumar,
has.
the mother and one witness,
One.
the another person.
And he
So
was
far as the
actually-
Sandeep is concerned, only role is hospital. You have to argue three.
Yes, Sandeep, my lord, I find, my lord, because his name is.
I think you may segregate your argument. You should argue whatever you want to argue with Sandeep separately. You should argue separately so far as a Sukumar, and then you should argue separately so far as a Sahib is concerned. I think that would be easy. I am talking about Sandeep. Forget about Sahib. Their role we will come. Sandeep. What the Sandeep has done. What? Just we wanted. Section 34.
Now,
That's
my
all.
lord, Sandeep.
What Sandeep has done.
Now, what Sandeep has done is this, my lord. Now, Sandeep's presence and taking of his presence is, my lord, I'm trying to understand because of the fact that he had taken body along with the others. I mean, the deceased along with the others. It is not a roadside accident.
No, he understands.
So his presence in the house of Sahib.
So suppose there is you can't segregate the accident in a different fashions. The accident connotes multiple things by which the accident may occur. It is not that the accident may only occur on the road. The accident may occur in the house itself. It may occur in the bedroom itself. It may occur in the bathroom itself.
Yes, I'm grateful. And that means, my lord, Sandeep's presence in the house where this happened, my lord, it probabilizes.
Secrets আমি বলছি যে ওর রোল তুমি ওখানে গেছো তুমি একটা প্রবলেম করছো প্রিজাম্পশনের উপরে হচ্ছে
No, my lord.
You will hear him, don't worry.
My lord.
We'll hear him because he appears to be very, very
He is
energetic in this regard. We will hear him, don't worry.
Before the trial court, my lord. And
That's why we will hear him, don't worry. We'll hear him. Let us see.
Now, my lord, what I find is this, my lord, the presence of.
As you wish. We can't compel you, as you wish.
The presence of Sandeep, my lord, or Sandeep accompanying this person, not accompanying only, but he has played a vital role in getting a person admitted in the hospital.
Then what
Yes,
motive?
now it has got two angles.
Now, what motive one can?
Yes.
A person desperately trying to save the life of the victim. He has been playing a very proactive role in bringing into the hospitals, and then when the hospital says we can't do it, referred it, taking him to the different hospitals and then moving it throughout, as it appears that this particular Sandeep was all along there because the victim survived for 7 or 8 days. Now, all these things together, because in order to attract 302, there must be a motive. And the motive has to be proved that he has a motive.
Yes, ma'am.
Now, only thing is linking him because he accompanied let us, for the sake of argument, let us see that he accompanied the prime accused and taken him to the hospital. Then what role can be attributed to his conduct? One has to see.
Oh, the role which he has played, my lord, is this. When we accept that, that he was in the house, now, thereafter this happening had occurred, and out of good gesture, my lord, he wanted to take and save him. That means, my lord, he had witnessed the entire incident. 201. But did he come with a thing to tell did he lodge a diary or inform the police that, well, I had tried to save him? But this is the person, how he managed to get the.
What is a normal human behavior, sir? The moment somebody has sustained a grievous injury, the first and foremost humanitarian approach which should be given is to save his life.
Yes.
It is not expected that he will just keep that injured on the road and then rush to the police station and then lodge a diary that this is what has happened.
No, not
I think
immediate
the
logic.
Supreme Court in many
Yes,
cases have already
Not immediate
deprecated
logic
this
of the
thing.
diary, because this
It
person
says
did not
all the principles have gone.
But immediately after his death, that is after 3 to 4 days, his conscience, if he would have not been involved in this manner, he would have immediately.
Suppose if his
Clean rest of
conscience,
himself.
if his conscience is that he really fell from the roof or from the whatever, the court story has not been believed from the roof, then why a person will go and say it's a murder when he believes that it is not?
Now, my lord, if your lordship will kindly see, because this is the expert, medical expert is PW9.
This is a very important one. This is a very important. That's why I was inviting your attention to this. That what the doctors
Yes.
have said. Certain bruises were found
Yes.
on the body, but the doctor has not ruled out. He says that this is because he was operated upon, and there is every probability and the possibility of those bruises to come. Look at the
Lordship will
evidence.
kindly come to page 60, my lord.
Please.
PW9.
Please.
My lord, he's the PM doctor.
Yes.
My lord, page 61 is the number of injuries that has been recorded by him.
But that has to be correlated with the earlier part of the evidence.
Yes,
If you come to page 60.
Yes. I found the following injuries at the scalp. There was a.
No, you have to read it from
From the
page
beginning.
60, the line about fifth from the top.
Yes. I was.
Postmortem was performed as per the Alipur police station inquest number
dated
such and
so
such
after
on
performing the
24/9.
Yes.
After performing
postmortem-
I found the following injuries. What? At the scalp, there was a stitched wound on the left side of the frontal parietal and the temporal region. It comprises of 16 stitches for a length of 5 inches. It was curved. On hand lengths, it was seen that there was a lacerated, it should be a lacerated injury of 2 inches into half, which was extended on either side by a surgical measure. Please, surgical measure.
Yes.
After removal of the stitches, it was seen that the portion of the bone measuring such and such was surgically removed. So that because he was operated upon.
Yes.
The part of the brain underlined, the bone was under pressure as just removal of the bone brain was coming out continuous. On dissection, a huge hematoma was identified at the same sizes there. Evidence of vital reaction was seen. On the same side of a scalp tissue, of bruises of such and such rotate. It was brownish black in color. Then bruises on the right side shoulder, you will find bruises. That's why I say there are a lot of bruises found.
Yes.
Now, look at the evidence. He says that in my opinion, the death was due to effect of a injury, head injury. So he opined. Antemortem and homicidal in nature. First time he brought that element. Homicidal, antemortem and homicidal in nature. First time. This is a PM report in original. Then you come to the cross-examination where the very internal important.
Yes, Miller, for all. That is from
Is
page
very good.
61. They tried to contradict in the cross. The heat or the impact may cause intracranial hemorrhage, which is commonly known as cerebral hemorrhage. Certainly, there are several reasons for oozing out blood from ear and nose. At the time of holding the PM, I did not take any help of other forensic expert. And as I myself is a forensic expert, I do agree that if a man fall from scooters, motorcycle, rickshaw van, and sustain injury to the head, may cause intracerebral hemorrhage. Injury to the middle meningeal artery may cause bleeding in the middle cranial fossa, which is revealed as bleeding from the ear. Injury from meningeal artery may be caused by impact. Normal pulse rate is fixed at 72, and in medical science, if it is less than 60, it is called bradycardia, and more than 100 is stracardia, which is pathologically. Bradycardia and trachardia falls in the category of abnormality on the wrist and dorsal part. There are under the skin tendon. So small muscle weight of solid substance depends on the mass of the instance. If anybody hit on another by a solid substance like iron rod, solid bamboo pole, at least it will cause an injury on the soft tissue on the relevant part of the body. Generally, common rods are found with 1.5 inch or 1 inch diameter. Well, means blood less to the viscera. The bluish mark on the left cervicular region is superadded with bluish sustained into the central line for the intravenous infusion. Superadded area is due to medical treatment. I did not indicate any bluish on central midline. The bluish on the left, right is sustained by trauma. I do not agree totally. If anybody hits by any solid substance on dorsum or wrist, there is every possibility of fracture and swelling. So, my lord, because there is no fracture found. So he also rules out like that if one is hit, my lord, there may not be a fracture. I do not agree that the case of trivial injury, hemorrhage do not cause simultaneous, but in the case of grave injury, the hemorrhage causes simultaneously. In CT scan, almost all soft tissues injury can be seen exempting some injury. In the minor or grave injury, cerebral hemorrhage can take place. In case of bluish color changes from time to time. It is not a fact that bluish can form easily where muscle mass and soft tissues are less. I have not found any injury on the rib. Not a fact that the story of bluish in PM and report. I have ventilated on the instruction of de facto. So when even the finding,
that was a suggestion.
yes, even the finding, my lord, they have given a suggestion.
Yes, he says that no, I have not.
Yes. That has been denied. Yes. Now, at the time of holding PM, if of the dead body of Dio of this case did not show me any iron rod or bamboo pole to take opinion.
Obviously.
It is not written in the PM. My lord, no, because my lord, no weapon was seized because my lord, it happened in their domain, I would say. So like, what has happened, my lord, is in their house. And whether they immediately took the deceased, my lord, they had ample time to remove all the evidences.
Nothing was seized by police.
Nothing was seized.
No. Because the timing, if you say that the mother and everybody has shown a time, they have said that when he was taken from the house, that timing was given.
No, but that does not mean, my lord, that no one in the house to take care of
now,
it.
please, and the timing of the first hospitalization is also given. Now the gap appears to be of very small.
But that was sufficient enough.
That's why I'm saying is small. It does not really.
No, my lord, the timing
is longer time.
Even if it is half an hour, my lord, like if the work that has been done, my lord, if someone wants that, that this should be all removed, it can be done.
No, it's removed. Then the IO, the investigating officer, must have written something that we does not found any kind of a things there.
Even the dresses, my lord, they were washed and returned to the victim's mother.
That was one of the waste, and some dresses were given by the hospital people.
Because the one which was the victim was wearing, my lord, that obviously, my lord, he cannot be taken.
So blood stain or something of that kind must be there. It is not that everything. It is a waste which he admits that I have washed because it was containing a blood stains. They admit. It is not that they did not admit.
So, my lord, the question of washing the clothes, my lord, and presenting it to the mother. So, my lord, that shows like they had the intention of, my lord, tempering the evidence. Now, my lord, the police comes. Now, my lord, I will take it as if, my lord, it has now the first plea that I have taken, my lord, information they give. fell from the court. What was the intention of giving this information? They could have easily said from the roof. Now, my lord, is from another building. It's from another building. Now, my lord, one of the witness comes and says, that is, my lord, the uncle, Majumdar. He says, my lord, that the body was seen there lying on the roof. He does not see any bottles. He was lying, and thereafter the story comes that he has fallen down. Now, my lord, as far as the drinks, now I'm coming to the drinks part. Since my learned friend and my lord, even they tried to make out a story, it was Vishwakarma, and there, my lord, there were a lot of drinks and others going on. Now, my lord, this person who is said to be an alcoholic or he was drunk, he was not in a position, my lord, when he was taken, as his lordship has seen. The first Dr. Arjikar, my lord, he has recorded. Patient party has said he was having a drinking bout.
That I have seen, because their evidence was even a this nephew or something who is himself a doctor, and the father told that
even here, my lord, there is no smell of alcohol.
no difficulty.
So, my lord,
That story of alcohol has not been proved to the ill.
I'm grateful.
It has not been proved.
If alcohol thing is not been proved, my lord, then
True.
Then in that case, my lord, the Majumdar's testimony, my lord, his evidence that he was lying on the roof, that also goes. These are all stories, my lord, that try to build up. One false statement, my lord, this to the other. That is from the court, my lord, to the rooftop. Now, my lord, the postmortem doctor, my lord, holds that yes, this is not a normal death. And then your lordship will kindly come to PW 11.
Page 70.
Page 70. My lord, PW 10's evidence report which he has prepared, my lord. Was also scrutinized by an expert. These people have got nothing against this the accused. They are trying to help the society and the prosecution, the court, to assist the court. From the tenor of their evidence, my lordship, they are trying to assist the court, not the prosecution. And one cannot also imagine that The prosecution will pay him the money, them the money to advise.
No. Where from you are having this notion? From where you are getting it? Who says so?
No, my lord,
No,
They-
this
their
can't be.
suggestion
They are the expert in their own field.
I'm good.
If they have come up, their evidence has to be evaluated.
On an, and my lord, in the cross, my lord, nothing has come out that they had proved the findings or the thing of PW 11 and 10, my lord.
PW 11 is a person whom all these papers were sent to have their
Second opinion.
That's all.
Yes.
So he has neither seen a body nor nothing. He has simply consulted the papers.
No establishment, my lord, he has said like on the basis of papers,
Yes.
I have seen this and the
So-
procedure that was followed and the observation made
Yes.
are cut. Now, the report which was submitted by him, my lord, was not challenged.
The report which he was submitted? What? What you said?
Page 19.
Page 19.
Marked at exhibit 19.
Exhibit 19, my lord, the report of 19/1. That is, your lordship will kindly come to page 71. I endorse the opinion as to the cause and manner of death in respect of Aninda Rudra expressed by the autopsy surgeon. Diagram of injury as per post-mortem report of Aninda Rudra is prepared by me and signed by me with official seal. This is diagram. It is stated 19/1, not with objection.
What objection? There is no objection.
That's what you said, without any objection.
Yes. The postmortem report has to go.
Yes, yes.
The maker, the author of the postmortem report, or the person who has conducted the postmortem report is before the court. And he says that it is mine document.
Yes, correct.
How can there be an objection?
No. When they, my lord, put an exhibit, my lord, obviously, my lord, tendered an exhibit.
Because was subject to cross-examination.
This is subject to cross-examination.
Yes. So postmortem report has been exhibited. There is
Yes,
no
yes.
difficulty. Who says no?
No, I will not on that.
So
Now, if your lordship comes to PW 16A, page 89. Sure. May I read it, madam? I think I'll read the whole. I am now posted as MO medical officer at CMRI on 17/9/06. I was posted at CMRI at 8:15 p.m. Mr. Aninda Rudra was admitted under Dr. Taposh Chatterjee, neurosurgeon, as bed number ICU 9. This is my handwriting. It bears my signature. On advice, admission marked Exhibit 22 series. Provisional diagnosis mentioned there. History of from bed. Who has made this statement? Now that's been revealed in the next few lines. This is a medical legal case. Paper prepared by me on the same day. Emergency number 16130 dated 17/9/06, 8:15 p.m. Name of the patient Aninda Rudra. Male 32 years old. Address 243 Nilmani Mitra Road, PS Kasipur, Kolkata 21, Guardian. And brought by Mr. Sandeep Ghosh.
correct.
Yes. Now address, my lord. This is the wrong address that has been given. Who had prompted him to give a wrong address? He has taken an unknown person. Time of occurrence, my lord, this. Place of occurrence, 619 Green Park, Lake Town, as stated by patient's party. Patient had a fall from bed and sustained head injury. So either he was there when the fall had taken place, or he is making a wrong statement. What was the intention of making a wrong statement? What was his intention of making a wrong statement? If he would have been doing it in a good Samaritan, of helping a person who is injured, to help him to save his life. Examination, patient disoriented, bleeding from left ear, details of injury from ward records, advice admission, so and so. Now, my lord, your lordship will see common defense by Shukumar and Shahid. At the relevant time, I was discharging my duties as MO. I'm not skipping that, my lord. Bleeding from ear may occur due to various reasons. No signature was obtained of the patient party in the report. Below my signature, there is no date. I have not put my registration number, not a fact that I have not discharged my duties, not a fact I have manufactured this document. Now for Sandeep Ghosh, cross. Age of the patient is mentioned as 32, is overwriting. There is no mention of name of the father, mention of name father of the patient. But he was disclosing. Sandeep was.
There was no mention that he does not know the name of the father, so he did not mention the name of the father. And the last line is important. I cannot say whether
whether Sandeep was present or not.
No.
No, my lord, he cannot. He could have been the most. My lord, he's a doctor. Okay, he has nothing to do with that house. He's got nothing to do with the my lord, the other appellants. And how could he be present in the PO? So that suggestion had given to him, my lord, that he was whether he was in the PO or not is a little confused.
Last time, PW19.
Now, my lord, the first IO is PW19.
Page 92. Discharge.
As such, my lord, we are just presently I am working as
page
94, my lord. I was interested with the investigation of that case. After receiving charge of investigation, I examined the complainant, namely Amit Rudra. He corroborates the FIR. I recorded his statement under 161. I examined 3 other witnesses. The mother of deceased, Shah and Rajiv Chaudhary, and recorded.
There are 2 investigating officers in
this
this.
This is the first. He's the first.
19 and 20.
Yes.
Now, my lord, then I examined some local witnesses under section 161.
And did not cite them as a witness. That is, they are very critical.
My lord,
Many people
this is
have
the-
said many things, but he
My
did
lord,
not. They are
witnesses
not
which I take my-
cited as a witness in the
But-
charge sheet.
Yes, they have got a right to take this objection, my lord, that this witness was not brought. This would have, if it had been produced and examined, I would have had a better chance. They had also the opportunity, my lord, to get the court to call any other person.
No, that is there. There is no problem. The power of the court to call any witness
Yes,
for the purpose
I'm
of
great.
proving a fact or the purpose of proving a document. There is no difficulty.
Yes.
But it appears that they were investigated during the investigation, but they have not been cited as the charge sheet witnesses.
So, my lord, now the thing is this, my lord, as a prosecutor, my lord, I would say, like I would try to make out the number of witnesses that is relevant per ones, my lord.
But those were very relevant.
But according to them, they're relevant.
No.
And if it has been left out,
These were the persons who appears to be of some importance.
3 other witnesses, Meenakshi Rudra, Sanchal,
Meenakshi Rudra is a PW2. Mother. Mother of the victim, PW2.
Kindly visualize. Second line, you read it and then that I examined Meenakshi, Saha and Rajiv Chaudhary.
Meenakshi Rudra, my lord.
I am going very short, my.
My lord, she is the mother. She is the
I
mother.
know. I was just saying. I was just a little bit, more. Say more in a concise manner. So 3 persons were interrogated, and then skip 3-4 lines from there at the bottom. As you got it from the right hand side.
Some
complicity of accused Sahib, Sukumar and Sandeep was found from the statement of
Witnesses.
means these persons who have been examined.
So, my lord, your lordship,
I read it. So these statements, these witnesses were very important witnesses.
No, my lord. Meenakshi Rudra, my lord, has been examined, my lord, as a witness. As a
Saha and Rajiv Chaudhary.
Saha, my lord.
No,
they have not been.
No. I'm giving you no. And so far as the Meenakshi did not name the Sandeep Ghosh.
No, Meenakshi did.
That's why I'm saying
no.
We are taking in the perspective of Sandeep first. We are in mind. What is the role of the Sandeep?
No, my lord, if Meenakshi would have, my lord, had named my lord Sandeep, it would have been too much. Because, my lord, she was.
That means because we find from the evidence of the Meenakshi, she did not disclose the name of Sandeep. So the name of Sandeep might have been disclosed by Saha or by a Rajiv Chaudhary. Otherwise, this investigating officer would not say, as some of the witnesses' statements shows the complicity of these 3 persons. So I raided their house. That means somebody else might have said, but he is not cited as a witness.
But subsequently, my lord, the medical record shows that
No, he was. That's why I'm asking. I will just seek the proposition of law in this regard. A person who is there took a very active part in the hospitalization or the treatment of the victim solely on the ground that he was there. Section 34 and more above, 34 more above, 302 can be attracted against him. Against him. This is what is a very important. We will come to Sukumar, no doubt, and we'll come to Sahib. But Sandeep, if you take it as a case, what is the evidence against the Sandeep?
And I find, and it is there on record, my lord.
Except that hospitalization, nothing more. Now tell us the law. What is the law on this subject?
Now PW 14 and also evidence.
Yes.
Yes, name of Sandeep is there. Page 84.
Page 84, your lordship.
Last.
Yes, you look at it.
Yes. Page 84, PW 14.
Yes.
Last 4 lines.
Now this is in cross. I stated that all of a sudden I found Bapta, Shai Kumar, Sandeep and some other person of the group were assaulting Bapta by lathi and rod and fist.
Where?
Sandeep is there.
Last 84, last 3 lines.
Yes. Show us role of Sandeep.
And that is.
My lord, now my lord is this here. The PW 14 says, in this cross, I found Bapta, Sahib and Sukumar Sandeep and some other persons of their group were assaulting Bapta by lathi and rod and fist. Thereafter, my lord, your lord, the next evidence is Sandeep, my lord, is the person who.
Now he has brought a story for the first time that he saw that Sahib, Sukumar, Sandeep and some other persons of their group were assaulting him with a lathi, rod and fist. Nothing came out because neither a lathi was recovered, nor a rod was recovered, nor any evidence relating to a bodily injury because of the fist and blows.
Now, my lord, the PO was under their control even after the offense was committed. The PO, my lord, was under their control.
Whose control?
My lord, of the Sahib's family.
Sorry?
Yes, my lord. The building.
What are you talking?
The building where, my lord, where the.
Under their control. What are you talking?
Victim was in the custody of.
In their custody, the victim was taken to the house of Sahib.
Sir, everything was there. They went. What is the role of the investigating officer? Not under their control. What are you talking?
Yes, my lord. If my lord, they would have been informed earlier while the treatment was going on, then in that case, my lord, they would have come and
Sir, the mother immediately within a very short period of time went, lodged a complaint. You were keeping silence on that.
very well.
You did not do a single thing which could have been expected from you. And it is the father, after he returned and after the death, when he came, he lodged a complaint. You then registered an FIR after a gap of nearly 7-8 days. And one thing you did it because that written complaint you have marked the same as exhibit. Complaint of the mother.
Lapses are the part of the tribunal.
Then who is to bear the responsibility?
No, my lord, that will not give them a acquittal. If the lapses are there, my lord, that will not do away with the evidence of the others.
True. That is then one has to bank upon the evidence.
Yes.
And then a corroboration.
Yes.
Mere statement will not do. There must be a corroboration. If this was the person who was declared hostile,
yes,
please consider these were the person who was declared hostile. Now he has said something which was never proved.
Now, my lord, the hostile PW evidence, my lord, is being corroborated by the postmortem doctor.
PW9. 84.
Oh, you are reading something different, sir. This is a denial. My brother has rightly pointed out, sir.
PW20.
My brother has more experience in this regard.
PW20.
It says, page 84, it says, I cannot say whether I stated that all on a sudden I found Bapta, Sahib, Sukumar, Sandeep and others were assaulting Bapta with lathi and fist. So he denied. And you are taking it in an affirmative sense. It is in a denial mode.
Page 100.
I cannot.
Please read. I cannot say whether I stated that all on a sudden I found Bapta and Sahib, Sukumar, Sandeep and other persons of their group were assaulting Bapta by lathi, rod and fist.
But he's not
So
denying.
I cannot say. What does it mean?
My lord,
And you are extracting that you said this.
No, PW27 I have confirmed it, and page number 100.
আমি তো judgment পড়িনি এসব আর্গুমেন্ট হচ্ছে
Page number 100, PW20 confirmed it. This part. And it is corroborated by the postmortem of PW9.
Yes, please.
Yes.
Now, if your lordship will come to page, my lord, 100. This is the evidence of, my lord, PW
20.
20.
Second I.
Second item.
He made the statement before police under section 161.
Now, my lord, this PW 14 has made statement under 161.
Page 100.
Now, my lord, it is his evidence. I know, my lord, your lordship will say like 161 not.
Yes.
Now, my lord.
I will definitely, otherwise you'll have to make it a part, that portion as an evidence.
Now he is confronting him, my lord, by quoting this.
Then you'll have to cull out that portion and make it as a part of the evidence, mark it as an exhibit.
That is not possible.
My lord, if
my brother would be more
if I quote it, my lord, and if I quote, my lord, and if he can contradict me, I'm open for a cross-examination.
What is the law? What is the latest judgment on this? That once you say that there is some kind of an admission in 161 or contradiction, will you not confront that witness? And that portion of the recording of the statement under 161, will you not bring it?
No, he has been confronted. Your lordship will see. Page 100. I recorded statement of Rajkumar. It is a
second.
Yes, continue.
The fact that witness Munna alias Ansar Hussain stated during 161 that about 1:30 p.m. I visited Sahib's house park and that Sahib's wife told me that Sahib was flying kite on the roof on 24/1 with Bapta. And that at time I went to the roof and that it was around 2 to 2:30 noon. And that at the time I went to the roof, I found Bapta Sahib are quarreling and dashing with each other for the dogs. All of a sudden, I found Bappa Sahib and Sukumar Sandeep and some other persons of their group assaulting by lathi and fists.
So it is confirmed.
Quote unquote.
First it was confronted to the witness and then to the eye, and I admitted that. And it is corroborated by the postmortem of the PW.
Now, if your lordship, my lord, sees the injury recorded by the my lord, the postmortem doctor.
And his opinion.
This is corroborated.
And his opinion is that due to hot ground substance, such injuries could be caused. Page number 61. Page number 61. Sir, is page number 61. Will you get a board?
Now, if your lordship will kindly to come to page 103, Sandeep's cross.
Statement of the mother.
He has not even touched it. Sahib Das crosses, my lord, at 102.
And it is confirmed in cross-examination of Sahib Das at page 103. Report থেকে 4 line. Fourth line from top, 100 page 3. I recorded statement of Sheikh Munna Ato. So there is no reason to disbelieve the recording of statement of PW14 by PW. Report থেকে 4 line. Page 103. I recorded statement of Sheikh Munna in cross-examination. I reported the statement of Sheikh Munna. The Sheikh Munna also witness he was examined by the eye and the statement was confronted and corroborated by eye.
Yes. Proceed. Now, my lord, 103 of lordship comes. I recorded a statement of Sheikh Munna 611.6. I do not know how many.
In cross-examination, it is stated, admitted he was examined. PW14 was examined by the eye. It is in cross-examination.
So, my lord, this is an admitted position, my lord. Munna was examined and his 161 was recorded.
It is in cross-examination.
So that is in existence. And the quote unquote, my lord, was also
also rated page number 71. Now 71, page number 60. Page number 61.
Yes,
the postmortem doctor is a part of the opinion part of the injury as mentioned above. A part of the disease corroborated the evidence of PW14.
at the risk of taking your lordship once again to the evidence of postmortem doctor, page 61. The last from the bottom, my lord. Has the lordship got it?
Yes, sir.
The injury as mentioned in report may cause death.
If anybody
is hit by a blunt substance and heavy substance, it may cause death of a man.
So it is corroborated the evidence of PW14.
So, my lord, 14 says he was hit by blows, lathis, and now, my lord, your lordship will see the cross, the heat or impact for all. Now, if your lordship comes to page 62, towards the bottom. I do not agree totally. If anybody hits by a solid substance thrown on a wrist, there is every possibility of fracture. Because they wanted to make out a case if they were struck by a hard substance, my lord, or a lathi or a rod, or there would be a fracture. There's no fracture. And the doctor, my lord, postmortem says, no, it is not always. Not necessary. Always. Now, my lord, 313, if your lordship would allow me to place. I'll just take a lordship a few, because opportunity is given to them for clarification. No matter if I know something, I can with authority say, no, this is false. If I know, or if I know also, I can say, yes, this is correct. When I say this is not correct, I'm taking it upon myself that I know it. Well, the first this is of accused Shahib Das. Question number 3, page 105. Amit Rudra, question number 3, madam. Amit Rudra has deposed that his son Anindo had intimacy with Raja Ghosh, Bitu Sarkar, Sahib Das. Do you have anything to say? They have no friendship. False. Now, my lord, your lordship will kindly the next page. He further, that is question number 7. He further deposed that his son took 2 mobiles, so with him and his wife tried to contact over phone so several times, but she failed. You have anything to say? No, false. No, false. This witness further deposed that 10-15 minutes, Dr. Boral again telephoned him and informed that son's scan report is bad and operation is required, and that doctors of PG hospital advised to take the patient to Chittaranjan hospital, Paksakas, and doctors of Chittaranjan hospital again advised to take him to CMRI. You have anything to say? No.
Then why did I? Intention can be gathered from this.
Now, my lord, there is a the question 12, my lord. The witness father deposed that Dr. Boral told him that Dr. Boral only took rupees 5,000 with him, which is not sufficient for admission. Hospital, and he handed over rupees 5,000 to mother of Sahib and is going to home to take more money. No, false.
Still said no, false.
Number 108, page number 108, my lord. No, Mithu is the person, my lord, who had brought the thing and handed it over to the father of Hindu. The witness father deposed Mithu bought the rest material of Bhakta from the house of Sahib and handed it over to him. These articles were 2 mobile phones, spectacles, full pant, and 1 handkerchief and 1 washed ganji. You have nothing to say? No, totally false.
This time said totally false.
Totally false.
If you have the special knowledge, would have come with us.
So he goes across the board, my lord, even to take upon himself. This witness father deposed on 21 and sent his wife to lodge FIR. Lodged FIR against Biplab Sarkar, Mithu Sahib Das, Srimati Ranjana Das, Mother Sahib Das, Sukumar Kormokar, Sandeep Ghosh, and many others. You have anything to say? Totally no, totally false. Similarly, your lordship will see this witness identity. Not like this type of person, my lord, the conduct. Well, he tries to escape by the page question 26. The witness identified the accused Sahib again by pointing out that he was wearing white shirt and blue stripe. You have anything to say? Police identified them. Police did not identify them. But he was identified in the dock. Now, my lord, question 33 at page 109. Srimati Meenakshi Rudra deposed on seminar that her son was in home. On that day, Sahib Das, my lord, very well, this part, wedding number so and so, and their repeated requests, her son went with them. You have anything to say? We did not know his house. Now, my lord, next page, 110 page, question 41. Question number 41, my lord. We will be to depose at 7 p.m. maternal uncle of Sahib telephoned that her son did not fall from cot, but he fell down from the roof. You have anything to say? Totally false.
Most important. What is the accusation? Fall from roof or fall from cot? Denied everything.
Now, my lord, question 44. She identified, next page, my lord, 111. She identified motorbike number so and so, saying that there was a motorcycle which her son was taken from her house by Sahib Das and Sukumar Kormakar. You have anything to say? Totally false. So that means he had the knowledge.
He identified the motorcycle.
Without having knowledge, either you say it's correct or it's false. He must have knowledge.
If they have the special knowledge, why they have denied this?
Now, my lord, question number 57, my lord. He doesn't make any comment on this. Page 112. This witness further deposed that Dr. Tapas Chatterjee informed him that Anindo suffered internal hemorrhage and needed operation. That is not possible to receive such injury by fall from roof. Eventually, do. This is very vital. Now, my lord, question 64, page 130. No, my lord, question 59, 130. The witness further deposed Sahib Das Sandeep Ghosh was present at CMRI along with another man, that is another accused, and identified all three of you. You have anything to say? Totally false. Anindo Rudra introduced them.
Anindo is dead person. Anindo and his Bappa is dead.
Now, my lord, question 64. The witness deposed he was taken to Chittaranjan and thereafter CMRI hospital, where he gave rupees 5,000 to Sahib Das, mother, for admission. Bapta and Sahib mother gave out, but one of the boys, and he returned home with another boy. You have anything to say? No, totally false. He has conspired against, that means he is trying to make out a case of conspiracy. For it is for him to prove it. That did he prove that we have conspired against him? Next, my lord, is page 66. This witness has also deposed that Bapta died on 24/9/06. If anything to say, no. At least the death, my lord, is been admitted. Now, the reason of the death, my lord, that is the PM doctor has stated. So, indirectly, he is also now question 68. PW6 Ahi Bhushan Ghosh deposed that he knew Anindo Rudra and Anindo was used to attend dog show with him. And Anindo was a good man, not addicted to any sevang. He deposed that on 17/9/06 he called Anindo over telephone at about 1 p.m. and Anindo told that he was very busy and he will call later, and next day he will come to our house, and later he came to know that he died. Having anything to say? No. Now, page 115, question 76. This witness deposed that he found the death of Anindo was due to effect of head injury, antemortem and homicidal nature, and that the said head injury was sufficient to cause death or ordinary
Course of nature.
Course of nature. You have anything to say? I am conspired against falsely. '77, my lord. Rajkumar Majumdar deposed that Sahib's mother was Sultan Sahib and Santanu, you have anything to say? And that Sahib was one Labrador dog. You have anything to say? No. So, my lord, their common thing, my lord, is having dogs, love for dogs, and my lord, there was also a dispute on that. Now, 82, my lord, your lordship. Question 82, page 115, PW 14. This is very important. Sheikh Munna has deposed that on 17/9, that is PW 14. 17/9/06, when he was going to the house of Amit Putta to collect payment, he saw Bapta living on a motorcycle on Gorakshabashi Road, and the motorcycle was driven by Sahib Das. Bapta was sitting in the middle, and another boy was sitting behind him. And Bapta told him that he would pay him after returning, and alternatively asked him to meet at 619 Green Park, and that he will pay him there. It is totally false. So he has taken it upon himself to prove this. This witness 83. This witness deposed that Bapta and Sahib Das were quarreling in the dog, for dogs in the house when he was working in Bapta's house for making super. You have anything to say? Totally false. So he has to be either there present, having knowledge. Now, page 117, my lord. Question 91. The witness deposed after examining some witnesses of as complicity of Sahib Das, Kumar Karmakar, Sandeep Bose were found to be, so he held right to arrest accused. You have anything to say? We have been conspired against falsely without investigation. With due respect, my lord, they were represented by advocates from the very beginning. They were having the legal experts who were advising them. No CRR, nothing of that sort. Against, my lord, improper investigation. They allowed the trial to continue, and when they're taking up this at the back end of the trial. Question number 92. The witness, the father deposed, he inquired about the exact PO was rooftop of Green Park. You have anything to say? Totally false. Now 93, he deposed that on completion of investigation, he submitted charge sheet against 3 of you and another accused, Ranjana Das. You have anything to say? Yeah, I have been conspired against falsely without any investigation. Now 95, my lord, do you have anything else to say about this case? I am totally innocent. I have been conspired against falsely. I never saw Amit Rudra and Meenakshi Rudra. All the witnesses were introduced to us outside the court. Who introduced?
Sir, again, they did not do any defense witness. Chances were given.
No, my lord, they had volunteered to give their clarification in 330, but they did not adduce any evidence. Defense witness. Now, my lord, 119, my lord, your lordship will kindly come to question number, that is Sandeep Ghosh. Question number 3. Amit Rudra has deposed that his son Anindu Rudra had intimacy with Raja Ghosh, Bitu Sarkar and Sahib Das. They have no friendship. With authority, he says. No, they have no friendship. False. PW 4, my lord. Question number 4, my lord. PW 1. Further deposed that Sahib Das demanded 2 lavender puppies from his son, which he refused to give, and for this reason, bitter relation grew up between his son and Sahib Das. False. Now, my lord, page 120, question 9. This witness father deposed that his son was not admitted at Arjikar Hospital and was taken to PG Hospital, and that lady telephoned his wife on the way to PG Hospital. You have anything to say? No, false. Now, question 12. This witness father deposed Dr. Boraj told him that Dr. Baraj only took rupees 5,000 with him, which was not sufficient for admission at CMRI hospital, and he ended over rupees 5,000 to mother of Sahib, and he is going home to take more money. No, false. Next page, question 17. PW1 further deposed that he asked Mithu to call Sahib to know the fact, and in presence of Mithu, Sahib came, and Sahib's mother, brother, and maternal uncle of Sahib were present. And Sahib told his maternal uncle, who told PW1 that the incident took place at the house nearby house of Sahib, on the roof of which Aninda alias Bapa fell down on the ground. Do you have anything to say? Totally false. Next page, 122. Question 23. The witness father deposed Mithu bought the rest material of Papta from the house of Sahib and handed over to him. These articles were 2 mobile phones, spectacles, full pen, 1 handkerchief, and 1 wash ganji. Eventually say, totally false. So he had full knowledge, my lord, to describe these statements to be false. That means he was present. Now, my lord, page 123, question 33. Srimati PWT Srimati Minakshi Rudra deposed that on 17/9/06, her son was in home, and on that day, Sahib Das and Sukumar Karmakar came to her house on a motorcycle bearing number so and so, and on their repeated request, her son went with them. Do you have anything to say? We did not know his house. Now, question 35. PWT further deposed, and at that time, Sahib Das was driving the motorcycle, her son sitting behind Sahib, and Sukumar Karmakar was sitting behind her son on that motorcycle. Totally false. Page 124, my lord, question 37. This witness deposed that those boys took her son in the house of Sahib at 619 Green Park. Totally false.
What is the evidentiary value and what is the relevance of the statements made under section 313? Tell us the law. You are taking totally false, not false. Is there any admission on their part? Tell us.
Well, 313.
And can this be alone a basis for conviction?
I'm not.
Unless it is an admission
No,
by
I'm
the.
not just relying on 313. I had taken your lordship 3 other evidences and
No, argue on that. You are taking totally false, half false, full false, slight false. What is the relevance in 330? It's a judge who says that against you, these are the statements which are coming. What do you have to say about it?
Your lordship, my lord, I would like to take your lordship. First of all, my lord, I had not started with 330. I did not start my submission with 330. I took your lordship.
You are reading, going question number 34, question number 35, and then totally false. That is what I'm saying. Has there been a clear admission, unequivocal admission? No difficulty. You can place it that this is what is the very. But he says no. What is the relevance?
No, because unless I have a knowledge, my lord, I cannot say this is false and this is correct. When I say
how it is to show us one judgment on this.
I'm betting a lordship.
Please show us one judgment.
Special knowledge to the
313.
Well, with the special knowledge of, well, he had a special knowledge.
We will consider that what can be regarded as a special knowledge and what cannot be regarded as a special knowledge.
I'm placing it before lordship, my lord. 313 obviously is a piece of statute. Is not, my lord, outside the statute.
He may be a licensed liar, no?
Sir,
no, this is an
Mr.
opportunity.
Negi, you have to argue law on that. 313 of the CRPC definitely bestowed a power upon a session judge to confront each of the accused
To make him aware
that,
that what he
that
is
what are the allegations or what are the evidence which are found against you.
Yes.
And to that, if you have to make any statement, you can make your statement.
This is exactly
And-
what I'm doing.
Sir, this is kind of in a civil proceedings, we call it an interrogatories. A
Yes,
kind of
that is prior-
interrogatories, putting a question and then inviting what is your answer to it.
Prior to the, my lord, the trial.
Trial. True, that is here.
But in course of trial, opportunity is given.
Is after the evidence is complete, then it is called.
Yes.
And then it's asked that these are the evidence which are
Yes, what
against
you
you, which are against you. Do you have to say something on that? He is not bound.
He's not bound.
Is
but-
not bound. Now, question is again, if he admits, yes, I admit, you can definitely take that part of the evidence as a valid piece of an evidence or having a very stronger evidentiary value. But if he says, no, I do not admit, it's absolutely false. Now the question is that how the questions are framed and what the answer comes. The questions are framed in such an ambiguous manner that answering yes and no both lead to a guilt. Will you still say that the question is correct?
My lord,
This is under the answer of the deformity. Case number 668. Special knowledge.
Now, one question is said, somebody asks, have you recovered from a madness? Tell me yes or no. Can you answer both yes and no?
no, I'm going to say,
Can you answer? Tell
your lordship will kindly see the answer which
say
is
yes, that means prove that you had a madness. If you say no, that means you are still suffering. You are still mad.
Had it been no, my lord,
Or neither yes nor no.
no. Because if you say like this is a false statement, false evidence.
Obviously.
I'm not referring to those where the answer is no. No. I am only referring to those, my lord, specific questions that has been given and which he is aware that he says is false.
Sir, under the criminal jurisprudence in a trial, onus lies on whom to prove it.
Yes. Onus is on the prosecution, but if the
Correct.
defense wants
What
to
is
take
your
up-
defense? What is your evidence? Don't go that he says totally false. You have to prove it. Mere saying totally false will not exonerate him.
The prosecution's case, I'm not trying to prove by relying on 313. I have taken your lordship from my lord.
True.
From
That's
the
why you
outer-
were placing 313. That's why we were critical on that. That what is the necessity? Show us if there is an admission, show us that part.
Well, only on that, my lord, because if they say like someone has, well, only on the totally false state. For instance, question 40 at page 124. This witness father deposed Dr. Swaraj gave rupees 500 to mother. I'm just for example. He says totally false. Totally false means when one can say it. If he has a knowledge, what is the truth?
No, what is the question? Please
Yes,
look
this
at it.
witness father deposed Dr. Swaraj Boral gave rupees 5,000 to mother of Sahib Das, and it was needed for operation of Hon'ble and returned home to take more money. You have anything to say?
Yeah.
What
So
is
if something came from the another witness, and then you say that he says totally false, means I never gave 5,000, nothing of that kind.
The question is not he gave. The question is this witness father deposed Dr. Swaraj Boral gave rupees 5,000 to mother Sahib Das as it was needed for operation of Hon'ble.
Yes, Sahib Das' mother is still absconding. How he'll say what has happened with the mother? How can he say? She's still absconding. You have not brought her.
Yes. Now, even if she is absconding, I'm grateful, my lord, your lordship.
And what has happened with her?
Yes.
Can anybody say?
But how can he say it is false?
Sorry?
How can he say it is false?
Can you say with certainty that these exact words have been translated by a judicial officer? Can you say anything?
Then in this paper book, my lord,
No. Somebody has said in a local language, and the translated version has been recorded in the 313. Can you say it's an exact translation?
this is not a ground taken by lord in the memo.
Can't. That's why I say you have to say that what is the
We can
what is the
we can just presuppose that this is not the proper way of
Examination of the.
examination.
By the
Because my lord,
sir, the difficulty is, I tell you, we have to find a distinction and which is real between may presume and shall presume. You are totally arguing on a presumption basis.
this part, man.
I'm again saying whether this kind of a presumption has to be understood in the legal sense.
I'm just relying on the 330
Legal
only for the
sense.
purpose that what is his clarification to the court.
Yes.
The court, my lord, whatever his advocate may have done, there is one chapter. Now, my lord, the court says very well, you have a right also.
True. Is
I
somebody
put this question to you.
I
If your advocate has not taken it properly, done properly, you answer it. You give a clarification. And now, my lord, we cannot say that 313 is just a mere formality. It has got some purpose. He is bound to give his clarification. And he gives his clarification. Well, this is his clarification, not our clarification. Without the intervention of any of the legal experts. Now, my Your Lordship will see question 50, 125. This witness identified Sahib Das and Sandeep Ghosh. You have anything to say? No, totally false. Now he comes up with a clarification. Amit Rudro introduced them. So, my lord, this person, my lord, he knew everything.
He admits the patient.
He admits the patient.
Then why he denied this?
Sandeep Ghosh.
Yes.
Yes.
And then in 313 he has said that he has a co-sharer dispute with the de facto complainant as well. So
He denied first.
So, my lord, he is an interested party. He is an interested party.
so he is related to a de facto complainant, he is related to a victim, co-sharer.
So, my lord, if he is known to the co-sharer.
So you can't rule out another
No,
theory when there is already a dispute with
Yes,
regard to that.
Right, it
Then-
means,
then-
my lord, he knows, my lord,
There was a
the
dispute in
Bapta and his address, everything was known to him. Why did he mislead?
Hmm.
Why did he give a wrong address? I'm putting the question to myself. I'm grateful to your lordship. Your lordship had found the connection that he is related to the de facto complainant. He has some interest, some rivalry. Then in that case, my lord, he had the full knowledge about my lord, this Bapta's address. So he wanted, my lord, to hide something, to mislead, to do away with evidence.
Yes, argue.
There was no specific response from the appellant.
Even under 313, I always feel that when there is a provision of in the law, because we cannot claim, because we are more interested in this from both sides. But, my lord, the client should be given, or the person or the victim should be given, or the person who is affected should be given an opportunity in all fairness.
No, it should.
And your lordship will kindly see, may I just read this?
Who says so?
Supreme Court cases, criminal matter 223, 1 SCC. Citation. Citation.
2023, volume 1.
668.
SCC, criminal.
2023, volume 1, Supreme Court cases, criminal 663. Corresponding equivalent citation is to 2023, volume 3, SCC page 372. It's a Prem Singh versus State. Yes, sir. Sir, tell me.
Page number. Same, same
the
DH.
head note, your lordship will see age.
Page number টা বলুন। আমি বইটাই সেন্ড করে দিয়েছি নেটের থেকে না বই থেকে দিয়েছি পেজ নাম্বার নেই
Other, as per medical evidence, they died because of manual strangulation, and obviously their death was.
Which one?
That page 668. 68.
668.
668
No, no. I do not rely on a head note, sir.
I'm sorry.
I am not groomed in this fashion. Please take us to the text of the judgment. Which paragraph you want it? Which paragraph?
I'm just looking. Because I have not gone through this, but my learned friend, my lord.
That is what we noticed since the beginning, because the way he was interfering. So I just thought, I told that I will hear him. We will hear him as well.
I should have satisfied myself. When was my learned friend, my lord?
We will hear him as well.
I think it will be proper on our part also to give him a notice.
The difficulty nowadays is only the head note and then rely.
Okay, like. Yeah. Thank you.
Page number 688 paragraph number 80 688 paragraph number 80
The 313, my lord, thing starts from paragraph 18. That is at page 688. Well, I'll take your lordship, my lord.
I believe you can come to paragraph 49 at page 703 of the judgment.
Apart from the above, we may usefully take note of the recent decision of the court and Samiti Commentara. Therein, the reference of section 106 of Evidence Act, the three-bench judge bench of the court noted that if the accused had a different intention, the facts are specially within his knowledge and which he must prove. Now, my lord,
then is important.
And if in a case based on circumstantial evidence, the accused makes response to an incriminating question to offer response which is not true. Such a response in itself would become an additional link in the chain of events. The relevant part of the denunciation by this court is written under SCC para 19. That thus, although section 106 is in no way aimed at relieving the prosecution from its burden to establish the guilt of an accused, it applies to cases where chain of events has been successfully established by the prosecution from which a reasonable inference is made out against the accused. Moreover, in a case based on circumstantial evidence,
whenever an incriminating question is posed to the accused and he or she either evades response or offers a response which is not true, then such a response itself becomes an additional link in the chain of events.
This is what you really wanted to say.
So my endeavor was that manner to that action. That they built up their own case, so like they had a special knowledge. And that also, my lord, is proved by them in their 330.
Fall from height or fall from roof. Court.
Now they make out a case, fall from court, fall from roof.
We have to prove.
Come to page paragraph 56 as well.
It is, of course, the duty of the prosecution to lead the primary evidence of proving its case beyond reasonable doubt. When necessary evidence had indeed been led, the corresponding burden which was heavy on the appellants in terms of section 106 of the Evidence Act to explain as to what had happened at the time of incident, as to how the death of the deceased occurred. There had not been any explanation on the part of the appellant, and as noticed immediately after the incident, he attempted to create a false narrative of accidental drowning of the children. There had not been any specific response from the appellant in his statement under section 313.
How 313 assumes relevance?
No, my lord. In isolation, 313 will know about no help. But because if the my lord, everything is there, the evidence comes
Sir,
against them.
first thing is when the onus, which is a primary or primarily lies on you, is discharged, then the question of shifting the onus that comes. Here the court is saying that when the sufficient evidence has been led, which may lead to completing the chain of the events, then this may also be one of the factor which is an additional link to the chain, nothing more than that.
Yes, I'm only playing for additional link.
Yes. But this is the link.
Yes.
I do not think so. The Supreme Court has said that.
No, I'm not saying this is the link.
Yes.
I'm saying like this becomes
You are putting an emphasis that look what he has said in the 313 response. So look at it, what is his. But first thing is a positive, you have to prove that yes, this is the evidence which really completes the chain. This is the chain. Here it is a starting point and here is the end. And look, this sequel of events completes it.
the chain of events, my lord.
That's all.
Yes, my lord, because my chain starts, my lord, he was taken from the house. Information given by them that he had met certain that incident occurred.
Anyhow, yes.
Now, my lord, the evidence that was put to him, my lord, the questions which are put to him on the basis of evidence on record. For their explanation. Now he has come with the explanation. And the link has become complete, my lord, because of the fact that he was taken from the house, corroborated by PW 14. Thereafter, my lord, he has been taken to the hospital. Not by us, but not by anyone, but by their people, by the appellants.
They give false name and false.
They given false name, and your lordship will also been observed. I mean, like you have noted that Sahib Das was known to them. This.
Yes.
They deny.
No, but he gives a false address, false name. Now they have been identified. Thereafter, my lord, the question comes of the whatever witness evidence had come on record that was placed before them. They were confronted with those questions to give their clarification and explanation. And I'm just referring to that as an additional link, my lord, to all the circumstances which I had placed before. Now, my lord, if your lordship goes to the judgment also, because now we have come to I have taken the lordship up to 313. Now, I do not find, my lord, the judgment of the court below that touches all the points. It's not left of.
No, what you said?
Now, since I have already come up to the point of 313. Now, what was the, my lord, thing before, all this were before the court below? And what is the finding of the court below? Is in the judgment, my lord.
Yes.
Now, my lord, I find the judgment that was, my lord, whatever is there on, is based on the evidence which has come on record. Appreciation of the evidence on record.
The judgment placed on record has come in the evidence. I do not. I did not.
On the basis of the evidence, judgment was passed.
The evidence was, my lord, before the court
Correct,
below. And
correct.
that was appraised and appreciated.
Oh, true,
and
true.
that was, my lord, that was recorded and with the, my lord, reasons. why it is
Correct.
being believed.
Obviously, then what is the necessity of the appellate court? Appellate
I'm
court
not
will not
saying-
be swayed or bound by that.
I'm
The
not
appellate court
asking
may
your
come.
lordship, I'm not asking your lordship. I did not take your lordship to the judgment first and thereafter, because I had taken your lordship, my lord, the evidences first.
Correct.
And thereafter, my lord, after I had come up to the 33rd stage,
Yes.
now the next stage was the judgment. That's all.
Correct. Correct.
So according to me, my lord, the chain of circumstances has become complete. Additional link, my lord, was given by 330.
Yes.
So in my humble submission, my lord, subject to what my learned friend says, in addition to what I have said, there is a foolproof case, my lord, of stand from my learned friend, my lord, this is the latest judgment. As far as 313 and the special knowledge.
My lord, in this judgment regarding the hostile witness, the credibility, if proved, it can be acted upon. So evidence of PW 14 can be considered. Now, sir, special knowledge, not only 313, there is a scope to give the evidence by the appellant.
315. He can give.
315 or
give.
315 is a written statement and 314 he can be examined as a
No difficulty. He can give.
but they did not, the appellant did not endeavor to that. Now, sir, if the special knowledge that the victim fell from the roof or fell from the court, that is the special knowledge, because the entire facts rest on the circumstantial evidence only taken by this Saib and Sukuma in the motorcycle. Thereafter, what happened? It was within the knowledge of the appellants. But they did not come before the court with the truth. Under the circumstances, what happened after taking the boy? Prosecution is completely in dark position.
True.
And the latest judgment, which my learned friend, that 313 can be considered 106 of the Evidence Act, which is the special knowledge, is to be proved by the appellants because it is their knowledge. This is not the prosecution case. Thirdly, question of motive. These case laws also guide us that in case of circumstantial evidence, motive may be proved, motive may not be proved. So for that reason, the prosecution case cannot go. Now, another circumstance, if the fact is not denied, the evidence is not denied, if not challenged, not suggested to the witness that you have deposed falsely, then according to section 4 of the Evidence Act, may presume shall presume and conclusive proof. Section 4 of the Evidence Act attacks to that effect. Unless the challenge is there, no denial, my lord.
That's the rule of evidence.
My lord.
And it originates from a very off-quoted judgment of our High Court by Justice P.B. Mukherjee, as his lordship then was. AEG Carapiet's case, AIR 1961 Calcutta. That's a very important judgment.
Yes, my lord.
That if the adversary does not put his defense into the cross-examination of the witnesses, then the statement which is made will be deemed to have been accepted or to be true. This is what is a rule of evidence. So section 4, when it defines may presume and shall presumes, the very fine distinction lies in between them. In both the cases, the first thing is that by evidence it has to be proved to that extent, and then the presumption would come.
So that is the position, lordship.
Anyhow, yes, we'll see to it. We'll see to it. Obviously, it is a case based on a circumstantial evidence, and it is a case based on a last seen together theory.
Last seen together.
Yeah.
And that part has not been challenged. Lord, in the entire evidence, neither in the theta T, not giving any evidence, that has not been challenged.
Yes.
And as the case rests on the circumstantial evidence, on each and every point, it cannot be proved by the prosecution witnesses.
Yes.
To some extent, some investigation was not done according to law, but that can be considered, that under the circumstances, it can be considered. My lord.
Thank you.
We are going to give the reply. Kindly give us a date, short date. Right now.
Still, we are left with something.
Mr. Basu is going to give the reply.
What?
Lord, in respect of Shondeep Ghosh, that is.
Because I was just expecting an argument from Mr. Negi separately for this accused. Because I find the 3 different arguments were advanced by 3 set of lawyers for each of them. So I was just thinking about it, that one for Sandeep Ghosh, one for Sukumar Kormakar, and another for Sahib.
This one, Lord, all are on different footings. So for the
common.
No, Sahib and Kormakar was common. Sandeep was always represented by a different set of lawyers. So I pointed out to Mr. Moitro when he was arguing for Sukumar Kormakar that what you have taken Sahib together, then how can you say that?
Exhibit 14. Exhibit 14.
Yes, when Mr. Basu can come.
Or can we come back day after tomorrow, Thursday?
6:16.
Wednesday. 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 Day after tomorrow. Wednesday. Day after tomorrow, madam.
Then come on Thursday then.
Thursday.
I'm in advance asking your lordship if I'm not being in a position to come, madam. Because then in that case, your lordship will not.
No, that's true. We wanted. Look, this matter was continuing for a pretty long time. Your junior was there. So if he was there. I said, what is the necessity? When you are here, at least you should keep the court busy. If you have any difficulty, this cannot be done. You could have said.
Well, I never knew a stone can create so much of a problem.
And these are all assigned matters. Can you visualize? Because it will not be heard by any other bench. So we have to complete it.
Your lordship passed the order for us. But it has become so viral, my learned friends might not have to face the wrath of the state.
The way it was projected, what can be done?
Very sorry to him also, but I had to court.
Yes. Thursday.
Thursday at 2 p.m.
Yes, obviously, not before that. Yes, the state concludes the argument. However, the counsels appearing for the appellants submits, that they may be given an opportunity to give reply. And matter may be fixed on another day. So in view of the above, let this matter be fixed on Thursday to be taken up at 2 p.m. Thursday at 2 p.m. চলো।
Extremely
আর
opportune.
হয়ে গেছে। কিছু মামলা নিয়ে তো কোনো দাও। ডাকো। পাঠিয়ে দাও। But it's an interesting subject. It's a learning process for me as well.
Civil matter, you get the evidence. Now we collect the evidence later.
No, it's a very the interesting branch of law. I just because when you talk about section 106, those are applied in a civil cases, mostly in a matrimonial proceedings. When a wife comes and asks for the maintenance, stating certain that this is the income of the husband, this is the duty of the husband to disclose it, because his income is a special knowledge. He has to discharge. So in those perspective, 106 are applied.
Even I am a migrant minor to this side. And it's very difficult for a migrant minor, even for the migrant bench and a migrant council.
It's not
Because everyone take us to be stupid.
Other day when I had concluded my part, my lord, I failed to say the most important argument that, my lord, it was a learning session for us, my lord.
No.
Indeed, my lord, I'm telling you, lord, my lord,
No.
for all of us, my lord, it was
No.
indeed a learning session, my lord, for all of us.
No, I am also learning. This is not this is a branch of law.
And when, my lord, the questions are put, my lord, intrigued by that, my lord, we tried to answer. It's always, my lord, unless the questions are put.
The next matter was extremely urgent. Next matter.
How much time will it take?
It will take 5 minutes. Your lordship has decided the issue already.
Decided by the lordship.
Resignation, Lord. Aims, I have to join Aims by 21st of this month.
Where is the other side?
Mr. Tapul Mukherjee.
Where is he?
Tapul Mukherjee.
Then bring him tomorrow. We'll start from. Bring him tomorrow. Oh, tomorrow. I means Wednesday. এখান থেকেই শুরু করো।
Day after tomorrow.
না কিছু না বাস একদম।
Fix করে নি। Day after tomorrow.